Good morning. I'm going to do that one more time. Good morning. All right. Well, welcome everybody. We are. I am thrilled to be here to open up what is the 4th annual IP Plus conference. This has, I just learned from Krista, turned into now our biggest conference of the year. I used to be the proud host of our largest conference of the year, the Cybersecurity and Privacy Protection Conference. We just held our 10th one last year, and I was thrilled that we got to 225, which allowed me to say was a record. Krista just told me it was reaching close to 300 with the online. That is extraordinary. That is extraordinary. Let's give a big hand real quick on that. So my name is Brian Ray. I'm one of the co-interim deans here at Cleveland State University College of Law. And as I said, very, very thrilled to open up this event. I'm not going to spend a lot of time because we're already running a little bit behind, but I do want to highlight a couple of things. Thanks to primarily Krista, but also our IP Advisory Board and our newer colleague, Mahtab Khan, Cleveland State University College of Law has built an extraordinary reputation and a very, very robust program in intellectual property and related fields. So we talk about it as intellectual property and innovation. We have a new center, which was really just a recognition of the many good things that Krista and Mahtab were already doing, including this conference. It's the Intellectual Property and Entrepreneurship Center, which will wrap in itself a number of things, including the certificate program that our students can take, as well as the many, many activities that Krista and the Advisory Council and Mahtab have been doing. We have several of the students from the IP student group here who are helping out today. They are just some of the many students who take the courses here and benefit from the activities that Krista, Mahtab, and the new center are doing. I want to recognize the student volunteers who are helping out today. Eric Fogel, if you're here, please stand up. They might be out front helping out. Caitlin Sisa, Julia Mandel, and Stacy Steger. I also want to recognize the sponsors who really help to make this event possible and also enable the center, Krista and Mahtab, and our students to do lots and lots of interesting and important things throughout the year. John Cipolla, who's at Calfee, Squire Patton Boggs, and Steve Oval from Squire will, if he's not here already, will be here and on one of the panels. Tucker Ellis and Sportech. Let's give them a big hand and thank them for their support. And now I want to introduce your MC and the organizer of this event, Krista Laser. I've already told you all the great things that she's been doing. I just want to underscore, Krista is still what we consider to be a relatively junior professor. She joined us in 2020, that's right? 2020, during the pandemic, was living in DC. In spite of that distance, and in spite of the fact that she's still at a point in her life where she's growing a young family, she just hit the ground running from the start and it's fired on all cylinders. She created what has now become a center, but was functioning already as one of our most robust centers. She publishes extensively. She is probably our most active social media presence, certainly on TikTok, the only one I think who has mastered TikTok, has managed to build a reputation nationally, but also more importantly to engage locally with our community and our alumni to build the kinds of connections that give our students jobs and that really engage and bring back to us, alumni who are prominent in the field but maybe have not been engaged so far. That's a very, very rare thing. There are many academics who build a national reputation, and that's fantastic. That's what we want. We want our academics to publish. We want them to build that network and to be involved in the academic space. It's far rarer to have an academic who then also is willing to engage practitioners and practitioners local who connect with the school and our students. And Krista does that. And does it all extraordinarily well. So let's give Krista a big hand, and with that, I will get out of your way.
So thank you so much for the kind intro. I'm really proud of what we've done so far with the intellectual property program here and the launching of the new Center for Intellectual Property and Entrepreneurship. And I really want to thank, because it takes a village to make that happen, I want to thank the people that help make this conference possible and help make our Intellectual Property Council possible. So John Cipolla, Carl Mersch, Ari Sherwin, Stephen Avil, and Louis Carrion, thank you so much for all of the work that you guys have done to help us get this far. It wouldn't be possible to connect our students with so many resources without your help, so I very much appreciate it. So we've got an exciting agenda here today. We're going to have a panel on finance, one on MedTech, sports law, and then we have a wonderful keynote from Donald Chisum and Janice Mueller, as well as in a fireside chat with judges on the federal circuit, and also including Dennis Crouch from Patently O. So we should have a real firecracker of some events today. I'm very much looking forward to it. So that I don't miss out on any time for our lovely finance panel, I'm going to start by introducing Carl Mersch, who is the manager of intellectual property strategy and monetization for Hilco Global. He also previously served as the founder of West 4 IP and an intellectual property consulting firm, as well as head of intellectual property litigation at Dow Chemical Company, associate general counsel of Eastman Kodak, where he managed intellectual property licensing, and previously litigator at Jones Day. And so I will turn it over to you guys. Oh, actually, one more thanks, which is thank you to our staff who are helping out so much. Jill Notrin, Conrad, and Rick Zhang up there, Eric Demansky, thank you so much for all of the work that you guys are doing. All right, I will turn it over to the panel. Thank you.
Thanks, Krista. So I'd like to welcome Russ and Patrick to Cleveland and thank them for coming. Russ is originally from New Jersey and went to college way upstate New York, Clarkson University, which is like this close to Canada. So when I said, hey, Cleveland in November, Russ is like, no problem, I have clothing for that. Patrick's a bit of a different story. He's from Louisiana originally, so I had to bill it to him as, it's like getting a flu shot. Like, get up here, get some cold air in your lungs, and then you won't have to get a flu shot. Actually, I joke, Patrick lives in Brooklyn, so he's well-versed in the weather that we have in the fall in the Midwest. Anyway, it was interesting this morning, because what I usually do when people come in from out of town is I take them on my little how Cleveland affects the way we practice law tour. So there's the Terry stop, there's the obscenity, you know it if you see it, there's where the bridge caught the river on fire, there's the Christmas Story house, there's all these things. I went out to dinner with Don and Janice last night, and I was like, hey, do you want to do this tour? And they're like, can we just go to dinner? I'm like, totally fine. So I thought I would skip the whole how Cleveland is relevant piece of the panel this morning, but then this morning I went to LinkedIn to get a picture of Russ for this slide, and Russ's background was the Calvin and Hobbes comic that's at the bottom of this slide. And I was like, oh my God, that's perfect. So here's how the story goes. Calvin and Hobbes is set in Chagrin Falls, Ohio. The author is Bill Watterson, who grew up in Chagrin Falls. Bill's dad is a patent attorney. So every once in a while, you'll see in the comic strip references to patent attorneys, and obviously the one that Russ had as his background on LinkedIn is relevant. And if you don't believe me, that picture right there is obviously Calvin stomping through a town. That is, for anyone who's local knows that's Chagrin Falls. And he's holding the world famous popcorn shop, which he's ripped out of the ground off Main Street. So that's the local connection to Cleveland and patent law. Anyway, Do you guys want to introduce yourselves, or do you want me to do it? All right, I'll do it. Russ grew up in New Jersey, went to Clarkson University for undergrad, has a degree in electrical engineering, went to Franklin Pierce Law School, and I went to John Marshall in Chicago. Back in the day when we started doing this as a practice, there weren't that many law schools that had IP programs, and Franklin Pierce and John Marshall were two of the ones that had significant programs, so that's how Russ came up. He started his career in Boston with two firms, one of which is Goodwin Procter, clerked for Judge Rader at the Federal Circuit, and then was an in-house lawyer at Avaya. And when Russ and I first crossed paths, he was chief IP counsel of Avaya. He's now CEO of Allied Security Trust, which Russell described to you and explained how he has all these interesting data about the patent market and liquidity in the patent market and how that sort of affects what we see in patent litigation and patent assertions and filings and things of that nature. Patrick is originally from Louisiana, undergrad at UNO, and then law school at Tulane. And then he was an attorney at two firms in New York that I have in my notes, Proskauer Rose and Hogan Lovells. Oh wow, I tried a case against Hogan. I wonder if we were opposite each other. And then for the past decade or so, Patrick's been in the litigation finance space with two firms, and now he was with Burford most recently, now he's with Certum for the last year. So Patrick's gonna talk about sort of the mechanics of litigation finance and trends and things that we're seeing in that market and really bring together how that availability of that lever for patentees has sort of changed or affects the IP market as we know it. Sound good? Okay, you wanna go first, Russ?
Yeah, do we have a controller?
Rick is up there, and all you have to do is say next slide, and he'll hit you up.
I'm going to stand up so I can actually see the slides that I'm presenting to you guys. Let's see.
Can I say one more thing?
Sure.
So we're going to do 20, 25 minutes, however long you want to take, and then we'll switch to Patrick. We'll do the same thing, and then we'll have plenty of time for questions at the end.
All right, and feel free to interrupt me with any questions as I go along. I won't take that much time. Yeah, we can go to the next slide. So just a little background on AST, just so you understand where all this data's come from. AST started up by 4 companies in 2006. It was HP, Motorola, Sun Microsystems, and Kodak. None of those companies are in their same form today. I met Carl back when he was working at Kodak back in the early days. But we are set up as a cooperative of high-tech companies that monitors the secondary market for patents. So we have a platform that's like the MLS listing for real estate, but for all the patents that are available for sale or for license on the open market. So what we do is we track all this data and we monitor the market. And when we have members that are interested in getting a license to a patent to prevent it from being a threat in the future, we go out and negotiate a deal for it. Next slide. Oh, thanks.
Yeah, Rick came down and he said, I'm not doing that.
So yeah, so we'll talk about why do patents matter? I mean, for those, it is a business asset. It's valuable. It can play an important role, particularly in M&A, corporate strategy, valuation of a company. It's sometimes used as an indicator of innovation. And they can also pose substantial risk for people too. They have real-world applications in finance, product development, corporate development. And the IP transaction market is a growing market that's been growing every year, really started in the early 2000s. So the secondary patent market really is just patents that are being sold after they've been issued. It's been increasing ever since the early 2000s. Back in the 1990s when I started practice, nobody was really selling patents at all. Everything was always licensing deals. But then it got to, in the early 2000s, people started acquiring patents, and they started acquiring patents for the sole purpose of litigating those patents. So that's why AST was created by these 4 companies as kind of a mechanism to try to get ahead of the threat from patents being sold.
I do miss the days when, as an in-house Kodak lawyer, we were actually selling enough products to be sued for infringement. Later in my career, we were sort of judgment-proof because we just weren't doing that well.
So 15 years makes a big difference. Back in 2010, the sources for patents, nobody really could find out what patents were being sold. There was no listing for them. There was few patent brokers. There was private analysis. Transactions, only the newsworthy transactions got reported. People didn't really know what prices were being paid for anything. Nobody knew what non-practicing entities are buying. Few companies were participating. The most significant company was Intellectual Ventures at the time. Then you get to now where we are today, 2025. There's lots of public sources of patents being for sale. IAM has a bulletin board of patents for sale. We have the largest, most comprehensive database of patents for sale or for license. Now there's all sorts of pricing studies out there, and I'll show you some pricing information as well. There's quarterly reports with trend information. There's a lot more information out there now for people to participate in the secondary market. So this is how big the secondary market is. Now this is based on prices of what people are asking for on their patents. But you can see here that the market is over $50 billion of what people are asking for on patents for sale. The red below shows you what's actually being sold. So there's still only a fraction of what's being offered for sale that's actually getting bought. But even the market for what's getting bought is still about $10 billion, a bit more than $10 billion. But there's a lot of unsold patents, which those often are recognized as risks, because if they're not getting sold, those people often want to monetize them in some other way. So we work, just to give you an idea of how many, there's new entrants into the market every year. We've worked with over 7,000 sellers and over 700 unique brokers over the last almost 20 years now, 18 years. But this just gives you kind of a rough estimate of how many new entrants there are in the market each year. So there's always new companies participating, new brokers, new individual inventors, lots of new participants in the market. And brokers come and go. That's a weird one. A lot of people we've been seeing actually brokering been decreasing a little bit as people have been taking on sales themselves. So how active are you? This is how many transactions have actually occurred. These are actually done deals. So there's been, just since 2010, 270,000 patent assets have been transacted in over 21,000 deals, involving almost 14,000 sellers and over 12,000 buyers. So the market has really been a very dynamic and robust market for many years now. And this shows you kind of the deal flow on a quarterly basis. About 500 deals are done a quarter between companies and NPEs and individual inventors, about 170 deals per month. So it is a very robust deal market. And who is selling, who's buying? It's still operating companies are the majority. That's where most of the patents are coming from, are from operating companies. And operating companies are the largest buyer of patents on the secondary market. Universities have been getting more involved in selling. Individual inventors, we buy about 10 times more from individual inventors than anybody else in the world. So we take some pride in trying to give a marketplace for individual inventors that often feel that they have no place to turn to with their inventions. So I just give you, Carl asked me to give you an idea of kind of who the top sellers and top buyers. So these are kind of the information we track, because we've analyzed every assignment record since 2010.
Can you talk about that? I was going to ask you that. How do you get these data?
Manual. We've been doing it, we've manually reviewed every assignment record since the beginning of 2010. We sort out the ones that are M&A, we sort out the ones that are just inventors to their companies, and we just pin down the actual transactions. Then we categorize them by technology, by type of buyer, type of seller, so we know who's buying, who's selling, in what technology areas. This helps us identify, like, say, for example, if we see that NPEs are buying a lot of semiconductor patents in one quarter, we know that that could make a potential threat for semiconductor companies coming up in the next quarter, year, or year, 2 years, 3 years. So these are the top sellers, and we've been seeing a lot more selling, by the way, because this is just the last 4 years. I took a a more recent thing, is Asian companies and Asian universities have really been hitting the market hard in the last couple of years. They're seeing a ton of stuff. You can see a lot of Korean universities, Chinese universities in there. They have been really selling a lot of stuff lately. I think you have some NPEs in there, some operating companies. The first chart is by number of actual portfolios, so actually kind of number of deals, and the second column is by actual size of the portfolios, number of patent families. So you see when you get to the patent families, you see more the large operating companies selling much larger portfolios like the AT&Ts, the HPs, Avaya, the company I work for, they're basically out of business now, but they've been selling off everything. So you get an idea of who's participating in the market from the sales side. I threw in top brokers too. So these are the people that are helping people sell portfolios. We like to keep track of who the most active brokers are. I didn't put it in here, but we also track which one of these brokers have the most portfolios that end up in litigations. So that you can kind of track kind of a threat indicator. Like certain brokers will say that their patents are going to end up in litigation and they never do. So we kind of know that's kind of on the BS meter there. But then we know others that they do often end up in litigation, and those are the ones we have to take more seriously.
We're not a broker, but we somehow sell enough patents that we made your bottom.
Yes, you are on there. Yep. And then from top 15 buyers, this is from since 2021 as well. We buy more than most anybody else at Allied Security Trust. So we've done 120 deals, and even more since I put the slide together. Siemens, Samsung's still buying a lot of patents. Jeffrey Gross, who's highlighted there, he's one of the most prolific NPEs out there. He buys a lot and asserts a lot. And you got Nokia, RPX, a few other companies in there.
Is IP Edge the company that was the driver of the disclosure requirements for litigation finance in Delaware?
They were one of the ones, yeah. And so their litigations dropped off the map for about 2 years, and now they're rejiggering and starting to try to come back from that. Yes. And then the top technology categories. This is by patent family, so the number of patents actually, so this is what we're dealing with mostly: networking patents, wireless, a lot of smart devices, circuits, artificial intelligence, a lot of interesting technologies. And our companies range all these technology areas. So here's the price. So I also looked at the patents that trade on the secondary market and end up in litigation. And this is the prices that are being asked for those patents. So you can see they range from as low as $10,000 for a patent family to $3 billion. The $3 billion one was interesting. It was an independent inventor that had a patent on some capacitor-related invention that he thought was worth $3 billion. You'll see a big spike there around $1 million. I find it very interesting is I did a lot of analysis. Most patents that end up in litigation, the patent owners just somehow circle around the number of $1 million. They ask for $1 million for their patent family. And those are the ones that are most likely to end up in litigation. But 60% of the portfolios we see are priced less than $1 million. Only 8% of lots are priced over $10 million. Which I always find this fascinating because you have, when you get into litigation, people are always looking for much more money. And I've been wanting to try this paper on this, about how there's such a discrepancy on what people are willing to license and sell their patents for. But then when they get into litigation, they're looking for 10 times, 100 times, 1,000 times more money than they were willing to accept on an earlier licensing deal or sale. This is just, I kind of broke down, this is kind of the pricing asked by different technology areas. So you can see where kind of the average and median price is by different technology areas. These are based on asking prices from the owners. So you can see some of the more expensive technologies, some of the least expensive technologies overall. So just some summaries on that part is, the transaction market is very robust. It is growing, new entrants every year. The NPEs are very still significant buyers. They're buying a lot more from Asian universities and companies too. We're unlikely to see the 2011 levels. That was when the Nortel sale went for $4.5 billion, though we still see some inventors that use that as their metric for pricing their deals. There's more brokers leaving the market as more sellers have been handling transactions directly, but brokers do add a lot of value as well. More international sales, they said. And the prices have stabilized. They were coming down every year since 2011, particularly since 2013, to about 2018. Since 2018, they've just been flat for basically 6 years or so. Now I'm starting to see the signs of them starting to go up.
At one time you guys published, can you talk about your buying program real quickly? And then at one time, at the end of your buying program, you guys would push out a report that said, this is how many patents we bought, this was the average selling price per family. Do you guys still do that, and what is the average selling price?
We do. So we do this, what we call the IP3 program, Industry Patent Purchase Program, every year. We've been doing it for 10 years now. It came off of a endeavor that Google was doing back in 2015, where they put out, anybody could submit their patents. They set a fixed price for it. So we do this program, there's no negotiation. The sellers name their price. We either meet the price or don't. We have all our members get together and they vote on it. And the average price for that for pretty much 10 years has always ended up being about $100,000 a patent family. Across a lot of different technology areas. That's just kind of where the membership and the patents, it just all kind of jives there. This year we did the program, we did spend more money per patent family. It was more like $140,000 a patent family this year. So a little bit more money that members are spending this year, I think because of the decrease in IPRs being initiated. So yeah, that's where we see the average transaction price on patents tends to be between, looking at different data, it can be anywhere between $100,000 and $250,000 a family. That's generally the given area where most patents transact across most technologies. So let's see, anything else I need to hit on this slide? Yeah, so lots said with realistic pricing and strong quality assets are transacting very quickly. We're seeing there's less time to react to certain portfolios. It's been a very busy first half. We did more deals in the first half of 2025 than we normally do in an entire year. So deal making has been extremely busy right now. And a lot of the patents that we see offered for sale are ending up in litigation. And I got some litigation slides here that I'll show you in a second. So why we care about these deals on the secondary market, and it's because of litigation. Here's just a chart I put together on damages over the years. The blue bar is the damages awarded. The red marks how much it was reduced. I don't have the reductions for 2021, 2022, and 2023 yet, but 2023 had $4.3 billion in awards in patent litigations. And we know some of that will get reduced. The Federal Circuit has never liked a large damages award. It's funny, I was looking back in that there's only three awards that have ever been upheld for over $1 billion at the Federal Circuit. And those were reduced greatly. One was for a $2.5 billion, $2.175 billion award that was reduced to $1.5 billion. Others have been reduced greatly. I've talked to a lot of litigators that almost don't want to win a case for more than, say, $400 million. You win a case for more than $400 million, you probably have about a 99% chance that the Federal Circuit's going to reduce it. I don't know why that necessarily is. I mean, when you got like Elon Musk getting $1 trillion pay package today, and you got companies making record profits, you would think you'd see more billion-dollar judgments, but we're not. It just scares the court, apparently, so they always reduce those awards. So this is why and most of these awards are off of patents that were transacted and sold and then litigated. So that's why I have so many members that are interested in the secondary market. You can see this tracks to the early days. back in 2005, 2006, people were litigating their own patents. The blue chart shows patents that were acquired and then litigated. And then today it's 93% of the patents that are litigated by non-practicing entities were acquired. Yeah, this shows overall litigations. This includes company-to-company litigations, all litigations. When you look at it currently in 2025, it's 35% of those litigations are litigating on patents that were offered for sale before the litigations.
And when you're an AST member and you get sued for patent infringement, Russ definitely has somebody on his team send you an email and say, hey, we saw this portfolio in this year and month, we saw it again in this year and month, and you ignored it both times, and now you're in litigation.
We do that for post-mortem purposes, that they can assess whether or not they made the right decision or not. But yes, we try to let members know when they passed up on an opportunity that could have avoided a litigation. Sometimes it's the right choice. Sometimes because the inventor or the patent owner was asking for an obscene amount of money that they were just never going to pay up front, and then they were able to settle the litigation for a lot less money. But we let them do that post-analysis so that they can decide whether or not they need to change anything internally. So these are the top plaintiffs using license or patents that were offered for sale and bought. So IP Edge, they bought a lot of patents. Cedar Lane, Jeffrey Gross, these are all NPEs that had acquired patents and then asserted them. And it used to be sometimes the litigation wouldn't occur until about the average time was about 3 years after the patents transacted. Now, currently, we're seeing it happen within 3 to 6 months after the patents transact. They're ending up in litigation. So we've seen over 4,000 transacted patents have been involved in over 11,000 litigations just in the last 10 years. It's about between 300 and 400 litigated patents each year that are transacted before the litigations commenced. Each of these patents have been asserted against multiple defendants. And the acquired patents are being increasingly used in litigation outside the US as well. And these are the technology areas where we're seeing the litigations. You can see the biggest area is electronics, web-based applications. Those make up the bulk of the litigations, but you can see it crosses a lot of different technology areas. So 4 takeaways, this is my last slide, and then I'll hand it over. The patent secondary market is large, complex, it's growing globally, yet very messy. Doing a deal in patents is very difficult. I talk a lot to people trying to sell patents, brokers, and even if you do everything right, you put all the data, you got your strategy, you put your claim charts together, there's still no guarantee that you're going to sell your patents. It's a very difficult market to transact patents. It may be getting a little bit better now. Assertions and litigations are continuing to rise too. So as we're seeing more deal making, we're also seeing more litigations. And demands are going up. I think this is mostly due to the reduction of IPRs. I've already been hearing from contingent fee counsel, which were reluctant to take on cases when they were going to be losing money defending an IPR. Now that IPRs have almost gone down to a 0% initiation rate, I see contingent fee counsel coming back strong, taking more cases, talking to patent owners about taking their cases directly to litigation, skipping even doing any deal making or licensing. And I know litigation funders are also getting more involved as well every year. So that's why AST's model works well for helping to make deal making easier, add some liquidity to the market, and reducing risk and cost over time for companies that are being proactive. I always like to say this, it always pays to be proactive. The companies that are reactive and everything's a fire drill always end up spending more money. But it's very difficult for some companies to get around being proactive. So I'll stop there and hand it back to you, Carl. Yes.
Your numbers, you seem to be focused on U.S. patents and U.S. litigation, but is there also a secondary market for European patents or Asian patents or
et cetera?
Yes, so we have done some deals. We've done some deals that have been for German patents only. We've done some deals for Chinese patents, but the driving force behind all these deals are always the U.S. patents. And now I just was reading recently, I think it was just last week, that now there might be an ability to assert U.S. patents in Europe. So it's going to make the U.S. patents even more important now.
I was sitting next to Russ when this news came in, and we both looked at each other like, WTF? But the UPC is taking a view that if the target company is domiciled in, for say, Germany, I don't remember the facts, I think it was a UK company.
I have to dig into it more too, but
Yeah,
it's...
well, I'll take a guess, because I think I had these right. I think it was a UK company, and the UPC let the patentee assert all their global patents, including a US patent, against that company because all the damages were flowing through that entity in the UK. So,
Yeah. So the US patents are definitely the driving force still all the time. That's why we focus on that. Yeah. But there is interest in always the foreign ones. Not as much interest in, people were talking about Chinese patents for many years, and most of the companies I talk to, they don't really care that much about Chinese patents. They don't really look at them that much as a risk, but has not developed into the story that it was presented to be a few years ago.
I bet Mr. Dempsey will have thoughts on whether they fund cases that are not in the US.
Increasingly, it's becoming a big part of our strategy, particularly in Germany, where the ability to get injunctions relevant to pending US litigation is an attractive part of our litigation strategies. So I'm coming at this from a litigation perspective. Let's try to... There we go. So our involvement in this sector, Cerdum Group, we invest on behalf of a $15 billion family office into all sorts of litigation, finance, transactions, commercial disputes, IP disputes, some mass tort. But IP is increasingly the busiest part of our business for a lot of the reasons that Russ touched on. But what is litigation finance for those that may be less familiar with it? At a high level, we are investing in a litigation asset on a non-recourse basis. So most typically, that's funding the fees and expenses associated with bringing the litigation. If the litigation wins, the funder gets paid a return. If the litigation loses, we take that risk. So we do a lot of underwriting on the front end to decide, is this a good case? You know, what are our likelihood of success on the merits? What's the quantum of damages and so forth? And it's relative to other asset classes. It's small, like it's not private equity, it's not venture, but it's $15 billion or so in capital capacity. And a lot of that is being directed towards patent infringement lawsuits. And so historically, that has been operating companies coming to us telling us, hey, my patents are being infringed. I'm a small operator. I don't have the resources to pay, my lawyers to bring these cases. And so we would pick up the fees, the expenses. Sometimes it's just IPR costs, whatever is needed, we'll put up the fees and expenses associated with bringing that litigation. And it has been kind of for as long as I've been in this industry, so about 10 years now, it's kind of been the tip of the spear in terms of litigation finance. More than other practice areas, it's almost been incorporated into law firms' business model in terms of we're going to take some risk, but we're going to offlay some of that risk to a financial partner. And so with the changes in the patent office, I think that will only increase in terms of the amount of market share that this particular practice area has in the overall litigation finance space. And so that's for a couple of reasons. One, as Russ touched on, you can get really large damages awards. You can, invest at scale, unlike, other types of cases where, there's one breach of contract, you're investing in one case. With patents, you may have multiple infringers, so you can make one investment on the same overall diligence process and have 2, 3, 4 cases roll out from that. To Russ's point as well, we very much are focused on the sweet spot of damages. We kind of tend to stay away from the billion-dollar damages awards. We want a couple $100 million. Fed Circuit's more likely to leave it alone if it goes up on appeal. But nonetheless, you can get big returns. In most situations, the technical underwrite is easier to do. Most of the information, 90% of it, you can glean from what's publicly available. And so there's a very regimented approach to our underwrite, as opposed to a tort case or a contract case where you may need to get into discovery to understand whether or not there's really liability here. And then, again, following on Russ's slides, it's a growing market. There's a lot of interest in looking to litigation to monetize some of these assets. And that's one of the trends that we're seeing, which I'll talk through. So the first thing, and Carl touched on this, there have been a couple courts across the country that have put forward disclosure rules where a patent litigant needs to disclose whether or not they've taken funding and the identity of the funder. And there was and Delaware, Judge Connolly in Delaware is the prime example of this. That New Jersey as well, Northern District of California, they have the same rules. That hasn't really stifled appetite for filing cases in those jurisdictions. Of course, we are, our first instinct is, can we get into Texas? Can we get into the eastern or western Texas? Just because it's a known quantity in terms of what the process will be. But we're not opposed. The industry generally is not opposed to continuing to fund in Delaware or some of these other jurisdictions.
I've actually never understood why plaintiffs, and maybe funders too, are so reluctant to disclose the existence of funding. Because for anyone that's been through the underwriting process for litigation funding, it is like the worst. I can't even tell you what it's like going to the doctor 4 times in a row to try to have them diagnose something. It takes forever. There's a million patent attorneys that are asking you all these questions. When you get through it and get a funding deal in place, I always want the defendant to know that 15 people looked at this and they think we have a claim here, so you should pay us. I've never understood why people don't want to disclose it.
I take a similar view personally. It's a bit of a contrarian view within the industry. I think the reluctance is more to avoid discovery sideshows. Defendants will take every advantage that they can to slow down the litigation, increase costs for the plaintiff. And so that's subpoenas, that's depositions, that's all sorts of discovery that they try to get. The courts, by the way, have said, by and large, you're not entitled to it. It's protected by the work product doctrine, and it's not relevant to the underlying dispute of whether or not there's infringement. And it also, I think, but the industry's approach to push back on all disclosure requirements has kind of hurt us in this fight that we went through over the summer. I don't know if this made it to on your radar or not, but Senator Tom Tillis over the summer tried to introduce, as part of the big beautiful bill, a very punitive tax on all litigation finance investments that would have taxed it at over 40% at the entity level, putting aside whether or not there were tax-exempt entities investing in those litigation funds. There's no ability to offset expenses, no ability to offset losses, so it really was a very punitive tax that ultimately got stripped out of the bill for violation of the Byrd rule, so a very, very parliamentarian reason to strip it out. But the fact that we have not been able to disclose all of the great investments that we've made, all of the operating companies that we helped put us on our back foot as an industry in terms of pushing back on some of the dialogue that was put out there by, the advocates of Senator Tillis's proposal. Whereas if our involvement had been public, we would have been able to point to countless examples of how really we're helping small businesses, we're helping patent inventors and so forth kind of right wrongs.
What kind of structural changes are you making to account for disclosure?
Well, so a big one is kind of avoiding just sort of changing the general model and sort of not just being a third-party funder, but just sort of taking control of it ourselves. I think more broadly in our traditional funding agreements, it's making clear that we are not taking control of the litigation, making clear that it's still protected by work product, and also just sort of changing what we're putting in writing and so forth. But increasingly, and by the way, so funding fees and expenses associated with an operating company or even an NPE's litigation is still the bread and butter of what we do in this space. We're still doing single case or portfolio transactions where we're sharing the fees. A lawyer is taking fees on risk and we're funding the remainder of those fees, and we're typically funding 100% of expenses. But increasingly, CERTM and the rest of the industry is more open to actually being the acquirer ourselves, as opposed to just being a passive third-party funder.
5 minutes, unless you want to take questions.
Yeah, sure. And part of this is to get around, if and when the Tillis tax bill comes back, part of this is to control the strategy ourselves. It's always a tension when we're looking at any particular opportunity. Are we more concerned about being disclosed? And it's not so much CERTM's disclosure, but we don't want them going into our investor stack of sort of going to them getting served with subpoenas and so forth. But do we want more disclosure, or do we want to have more say in the strategy, the control of the litigation itself? And so those are typically the things that we're thinking through. And this is something I think that the entire market is more open to, and there are more operating companies that are willing to sell their patents, and that's kind of the third point here. The companies that are coming to us looking to explore monetizing their patent portfolios through litigations are expanding to companies that you wouldn't typically think would be having these conversations. A lot of them, as Russ hinted at, are coming from Asia. Japanese and Korean companies are increasingly looking at the US litigation market and saying, how do we access this? How do we tap this? But a lot of them don't still want to be plaintiffs. So the acquisition model is sort of the approach there, where they will offload typically non-core patents to us or to some SPV for an upfront fee, and then they will take a tail in whatever the ultimate recovery is from those litigation campaigns and monetize it that way. So they can sort of spin off the patents, but still not sort of be involved directly in litigation. So as I said, we at CERTM, and I think in the industry generally, view patent litigation as the biggest driver of deals going forward relative to other practice groups. And I think that was before, some of the changes that have started to come out of the Patent Office. I think with those changes, I think we see even more opportunity here in this space. Any questions?
I wasn't clear about how this works for a practicing entity who's small and can't afford litigation. It seems if they're a practicing entity, they don't really want to sell the patent because that could create a whole bunch of problems. And if they don't sell the patent, how does it work for you funding them when you're not able to control the litigation, you're not able to control settlement? And doesn't that also create an ethical issue when there's this obligation to a funder?
Yeah, so typically in those deals, which again is the vast majority of the deals we do, we'll enter into a transaction with the operating company itself where we'll agree to pay a portion of whatever the legal budget is for that case. We're very focused on the front end in getting the right economics in place, the right structure, so that everyone's interests are aligned. If the funder is taking the lion's share of a recovery, the operating company is not going to act rationally. They're not going to take a settlement if it's on the table. They're going to roll the dice using our capital to take it all the way to trial if necessary. So we're very much focused on the front end about what is the optimal structure. Not every case is fundable too. Sometimes the economics are just too tight, depending on even if the liability or the merits is good. There just may not be enough room for us, and so we'll say no to those deals. Once we fund, we are a passive participant. We can certainly offer our thoughts and guidance on what we think should happen, strategy, et cetera. But it is ultimately the client's decision. We're not inserting ourselves in that attorney-client relationship. And so a lot of it really does come on the front end of, do we fund in the first place or not? Most of the things we see, we say no to. We only fund about 5% of the cases. It's got to sort of line up just right.
Great. Thanks so much for this. And Patrick, my question, it relates to the funders, and I think the biggest concern that people have, or one of the biggest concerns here, is that when we have secret funders, that there is a sense that a large number of them are foreign entities who number one, don't have American civic mindset, and might even have the mindset that they want to encourage divisiveness within America by encouraging this aggressive litigation. And I wonder about your thoughts on that.
Yeah, so anecdotally, I don't know how much outside investment there actually is in this space, certainly in terms of mainline funders. But I think more generally, kind of going back to the first question, most of these investments are passive investments. They're not dictating what a particular litigant can or can't do within the litigation. The other piece of this is just in terms of what we see in an underlying litigation. Most of the stuff that would sort of go to the sensitive things that we're worried about a foreign investor seeing are going to be marked attorney's eyes only. The funder doesn't get to see that. Like, the funder doesn't really get under the hood of a lot of the defendant's discovery or so forth. So in my personal experience, I think it's more of a red herring. I think it's something that the insurance industry and big tech have kind of floated as a bugaboo that just really isn't an issue. And there have been some individual states that have passed litigation finance legislation requiring disclosure of foreign investment. I think Kansas may be one. Not a hotbed of patent litigation, but nonetheless, it was a legislation that the industry generally supported because we don't really view it as an issue. Yeah.
Hi, Patrick. Question about IP cases that are funded, not this industry-wide. You can certainly speak to certain, but is there a hierarchy of technologies that are, from more likely to be funded to less likely to be funded?
I think we're technology agnostic. I think what we're more focused on is, at least historically, how likely are we to run into Alice issues, even if we have the better of the arguments. It has been unpredictable in terms of how those will be handled, and so we've stayed away from technologies where that's going to be front and center in the defense. We typically look for adoption within an industry so that there are past damages and we're not just looking for forward-looking or future damages. We typically look for patent portfolios where there are multiple patents, multiple families, open continuations, so that there's, optimal maneuverability going forward. But I think, in terms of technology classes, there's not a particular, at least in my mind, there's not a particular hierarchy.
Okay, thanks you guys. 5 minutes over for a panel that I'm on is actually under time.
Yeah, I actually have another few minutes, I think.
Oh, we do? I thought we were at a time.
Until 15 after. So we've got a few more minutes for questions. I actually have a question, more on the acquisition side, which is for the independent inventors that are coming either into your portfolio or into others. Where in the process are they typically? Do any of them get those acquisitions at the provisional patent stage, or what is that looking like for those independent inventors?
No, for us, we only deal with issued patents, and generally older patents. I mean, most of the patents that we buy are typically about 10 years after issuance. We find, because we're a cooperative, so our companies like to get together and share in the acquisition cost or the licensing cost. That generally means that they're looking to share in technology that's already been developed. If it's forward-looking technology, companies will often want to do that on their own, if it's something that they really want to practice in the future. But no, it's often issued patents and often a few years after it's been issued.
How flexible are the funding arrangements? What happens if the risk profile of the case changes as the case is evolving?
Yeah, it's a dialogue. I mean, typically it's not a lump sum that's paid at the outset of a case, but rather it's dripped in as the case progresses. And so each month as fees and expenses are incurred, the funder will pay that. And their funding agreements typically have a clause in them that if the investment is no longer economically viable, there may be outs there may be an opportunity to bring in, for the claimant to go find other money. Typically, though, we know litigation is inherently risky. It's a bumpy ride at times, and so I can't think of a single case that I've been involved in where we've pulled funding or otherwise stopped funding into something. But it's a dialogue as a commercial relationship with a counterparty.
I don't know if your company does this, but I know that some interesting thing that I learned a couple of years ago is that how litigation funders will actually sell cases from one litigation funder to another litigation funder. Sometimes a large litigation funder that can bear more risk will take a case through, say, summary judgment, and then they'll sell it to a smaller litigation funder that'll take it through trial. So these things can be transacted as well between litigation funders.
Yeah, that's right. I mean, it's a sign of a growing industry, which is still relatively nascent, but there is starting to be this secondary market that Russ is talking about.
Can you talk a little bit about the insurance wrap and how that has affected your business?
Yeah, so Cerdum actually, in addition to the funding business, we actually started as an insurance player, brokering all sorts of insurance policies for various insurers, including the ones that are most relevant are judgment preservation insurance. So when some of these big judgments happen, you can go to the insurance market, wrap them in insurance to protect against them getting overturned on appeal, as well as wrapping contingency law firms or litigation funders' overall portfolio to sort of hedge against, macro loss. The judgment preservation insurance market has largely fallen away, partly because there have been some really bad bets by the market. They have insured some of these really big judgments that have since been overturned were insured, and so now the insurers are on the hook to cover those, and so as a result, a lot of them have pulled out. I think that the general theory is, at least on the wrapping portfolios before they reach judgment, which is still a market, but you need to have multiple cases to insure. The general thinking is, and people use it to lower the cost of capital. If someone is coming to us to fund a case and we're bearing all of the risk, we're going to price it one way. If we know that there's a floor of what our recovery could be because there's insurance in place, then we'll price it perhaps a different way that's a bit more favorable to the claimant.
And just to give you the countervailing thought from the operating company, the defendant side of things, those insurance programs actually make a lot of these cases harder to settle, as you can imagine, too, because now, like you mentioned, there's a floor. So where you thought you might have been able to negotiate a better deal, they're not going to go below the floor that they're going to get from their insurance. So it can make some cases harder to settle and make more cases go through trial.
Yeah. By and large, we'd rather just take the risk ourselves. We feel confident in assessing that risk, and then we can go to the insurance markets on our end, on the back end, at a portfolio level where it's not impacting individual cases. But, the other people have a different approach.
So Russ, on one of your slides, you had mentioned contingent fee counsel. I've always viewed litigation finance as filling the gap that used to be filled by contingent fee litigation, that I think patent attorneys weren't very good at handicapping, and so firms don't let us do that anymore. Do you think that I think this thesis on your slide was that the increasing unavailability of IPR is going to resuscitate this contingent fee counsel notion?
That's exactly right, and that's what I'm already hearing, is that contingent fee counsel have now stepping up where they're allowing litigation funders to take that risk. They're now taking on that risk themselves. So it's more money for the law firm as well. Because if people have noticed just recently, they published that through the past month, the initiation rate for IPRs is 0%. So that's been given a lot of plaintiffs' counsel, has emboldened them to take on more risk.
Yeah, increasingly we're being asked just to fund expenses, with the law firm carrying 100% of their fees on risk, but not wanting to come out of pocket with hard dollars. And so we'll fund expert costs, IPRs if there is one, but with the lawyers just taking it all on risk in terms of their time.
We had another question from the audience here.
When you're looking at a funding opportunity, is it always before litigation starts, or you look at it at different stages of litigation?
Different stages for sure. Most of the time it's pre-complaint, but by and large it happens at every stage of a case. Sometimes there's fee fatigue if a case has been dragging on longer than expected, so they'll go to the finance market. Sometimes it's after trial and they're looking to hedge against the appellate risk. It really does vary throughout.
In closing, a year ago, Vaishali sat up here, who was the Commissioner of Patents, and we talked about IPRs and procedural changes and patent death squads and things of that nature. And in this practice area, I think we've all been doing this for a period of time, the pendulum swings back and forth. I can't remember a year where the pendulum swung further than this year.
We didn't even talk about, Tillis is retiring. He really wants a legacy of getting some of these bills passed, bringing back the strength of the patent system, the Restore Act, the PARA Act, bringing And I've been talking to a lot of operating companies that do truly believe that eBay is going to get overturned, or that injunctions are going to be back on the table, which I actually tell them is a good thing. I think that I've seen, so here's a trend I've seen among operating companies is the chief IP counsel at companies used to be 2 rungs down from the CEO. You had the CEO, the general counsel, chief IP counsel. IP for the last 10 years is becoming less important in a lot of operating companies, and you see the chief IP counsel now being 4, 5, 6 rungs down from the CEO in a lot of these companies now, and getting pushed down further. And I tell them, I said, you get eBay overturned, you bring injunctions back to the table, your job is going to become much more important in your company, so it'll be better for the profession as a whole. Because some of these patent attorneys in operating companies have done such a good job of making IP unimportant for their companies that they've actually put their own jobs at risk too. So there's this countervailing balance. Sometimes you do too good a job, you tell your company that they have to pay attention to IP because the sky's going to fall, and then when the sky doesn't fall, they say, oh, we can spend actually less money on this. So if eBay gets overturned and with the IPRs going away, I think patents are going to start taking on a little bit more importance in a lot of operating companies.
Anyone else? Okay, thanks you guys.
All right, thank you so much for that lovely panel. We'll take 1 minute or so to swap over to our MedTech panel. All right, so I'm really excited for our panel discussing medical technology and intellectual property today. We have a great set of panelists. I'll actually maybe just do a brief intro, and then I'll ask you guys to share a little bit about your work in the MedTech space as well. So we have Leah Brown-Lee, who is the President and Counsel of Lazurite. She has quite a lot of patents in her company that's been developed in-house. We also have Todd Tucker, who's a partner at Calfee and has experience handling medical litigation cases. And then we also have Matt McBride, who's a managing partner at Wave Strategy, who helps with developing intellectual property strategy, especially for early stage companies. So I'll open it up to each of you. All of you have a lot of experience in the MedTech space from different life stages of various companies. Maybe you can tell me a little bit about where MedTech falls into your work.
Sure. So Leah Brownlee, I'm president of Lazurite, so MedTech falls into my work as far as every day, 100% of my time. We developed and are currently commercializing the first wireless surgical camera for use in minimally invasive surgery. It is the only one cleared by the FDA. And so right now, that's an 80-hour-a-week job to break through into commercialization and to challenge the incumbent products from the big strategics in MedTech.
Yes, I'm Todd Tucker. I'm a partner at Calfee. I'm primarily a trial lawyer at this point in my career with a bad habit of still doing IPRs for as long as they're around. About 75% of my IPR work has been in medical device med tech because my undergrad degree is in biomedical engineering. I currently do have 3 IPRs that I'll be arguing over the next couple of months for a medical device company. And so we'll talk a little bit about kind of where I think things are headed with that part of my practice.
Thanks. So Matt McBride, managing partner, Wave Strategy. So we work a lot in the early stages of innovation, working at tech transfer offices, academic medical centers, and universities. We also work on the funding and industry side. So a lot of, I think, what we'll talk about, or I'll tend to talk about, is early on, maybe what some of the thought processes around what TTO decisions are being made around filings, and then what's important to industry and investors. And believe it or not, they're not all the same. So look forward to sharing more. Thanks.
Wonderful. So how can you tell us about how the market for medical technology or the experience litigating medical technology might be different than other technologies? We saw in some of the slides this morning, which I thought was interesting, that the sales price for some of those MedTech devices right now are a little lower than in some other categories. So I'd be curious about your experience about how MedTech IP is different than other areas.
Happy to start off. So I think in MedTech, as opposed to other areas, the development cycle, so the moment from invention to commercialization is much longer than other industries, which does change the value of the IP and when it's being commercialized. And also having it being heavily regulated, there's more pillars of protection from other commercialized devices or products.
Yeah, in my experience, there's been kind of two things, and we'll touch on both of them a little bit in more detail, that have maybe are one of the reasons why you saw those lower numbers. First off, with the Supreme Court and how it's handled 101 and how that's really hurt medical diagnostic patents, I think that's one problem, because you can get a diagnostic patent, but they're very hard to enforce. The other part of the equation in my practice, where I get pulled in a lot, was on the PTAB practice. And I think that because of the very nature of MedTech and a lot of government funding, a lot of university research, there's so many journal articles, it's really easy to find good prior art to go after a MedTech patent. Because think about a software patent, you're often limited to just what you can find at the USPTO or an overseas patent office, versus when you're talking MedTech, you have just not all these patents, but all these journal articles. You know, there was this old system called Medline that goes back like 30 years that we'll still tap into and find wonderful prior art. And I think that's always kind of made the enforcement of these types of patents a little bit more challenging.
Just to jump in briefly on that, you mentioned, I think at one point when we talked before, how that availability of prior art might be one way that MedTech is distinguished from a lot of other areas. And is that, you mentioned that might be because of the norms in that community as well. Can you tell us a little bit more about that and how that affects the prior art?
Yeah, so I think, if you compare MedTech to a software patent, right? So if you jump back to the kind of mid-90s, the Supreme Court starts to weigh in with like State Street Bank and some other cases that, yeah, it's possible for you to get a software patent or a MedTech patent. So software business method patents really take off. Why? Because there's no prior art. There's no place to go. The patent office doesn't have patents at that point. It becomes really, the validity of those patents is very different than a diagnostic patent or medical device patent, where you have researchers all the time are publishing articles because that may be part of their deal for getting a research grant. So you have just not the patent office in their library of patents, you have all of this just incredibly readily available journal articles. I have an IPR right now where the main reference came out of, it's a 40-year-old medical journal from Slovakia, the University of Bratislava Medical Society. And that's how, I don't know, it's not obscure, it's out there and you can find it on Google, like that. So I think that's why it's been a little bit different than some of the other areas.
And Matt, maybe you could tell us a little bit of what's your experience with seeing some of the differences in MedTech versus other areas? Is this an area where it's a lot easier to get invalidity determinations? Tell us more.
Yeah, so, right, so we do a lot of work in MedTech, but, we also do a lot of work in the therapeutic space. And we see, some of the same, similar rejections. We've kind of had to, go through the last decade together where things have definitely changed. And we've had to think about, building more of these defensive moats around technologies. And I think that's what we've seen a lot in the MedTech space is not relying on that initial filing necessarily, but really having a strategy around what's next and not just, right, having a patent to file a patent. It's ultimately working backwards a little bit and understanding what your industry partners want to see, right? And so is there commercial value? And right, and that's when working with, and this is now kind of coming from maybe early stage startup back to the TTO, is to say, are your IP partners, are your IP firms helping you really strategize on what's valuable versus what's a filing? And so I think what we've seen is overall, and I know there's people in the room who work very closely in this space, on the filing space, I would say probably from a MedTech standpoint, filings have gone down in volume, but in some cases, hopefully we see that they're more detailed and strategic when they are filed.
So Leah, I think that might be a great place to follow up with you, which is notwithstanding that some of these technologies can be a little bit more difficult to obtain patents on, they can still be pretty critical for the development of a company in this space. So can you tell us a little bit more about how intellectual property has been useful at your company and how you use intellectual property at your company, which might be a little different than some other folks that maybe do a lot of in-licensing or anything like that?
Yeah, I really want to touch on 2 points in the growth of the company. One is kind of the launch, and the other is the launch as far as the company is being formed, and the second being the launch of the product. So at formation of the company, we're a device company, which means we have a physical widget. We need a patent to protect it, to go out to investors and raise money so that they can feel confident that we are doing what we need to do to protect our intellectual property and our invention. And also at that point, really important is the processes of protecting the future development. And that means confidentiality agreements with all your vendors, invention assignments for your employees. And it's, in reality, it's like a 4-person company at the beginning, and you have to have these processes in place and these documents signed, and you have no money. But it's really important for the future financeability of the company if you're going and getting venture or independent financing. So our company went through that. I think our first patents were filed before our certificate of incorporation was filed. Then scroll forward, so that was 2015. 2022, we got our FDA clearance. We commercially launched the product. We did freedom to operate searches. We did trademark clearance searches. Before we went out of stealth mode, we dotted our I's, crossed our T's, figured out what the space is, making sure we actually covered the final product. We actually changed the company name. One of the big strategic companies out there had a product in Europe that was 1 letter different than our company name, so we changed our whole company name before we launched.
Great. Matt, do you have anything to add to how companies may strategically use IP in the MedTech space and why that might be more necessary in that space than in others, notwithstanding the difficulty of getting those patents?
I think from a few different angles. One, it is a very strategic thing, right? The one filing and expecting that to be why you're acquired or to elicit interest from industry is, I think, lost a little of that reality, right? Lost a little of that shine. And so being able to have not just the IP, but all the surrounding pieces that maybe enable the IP, right? And especially, when we're talking about diagnostics, that if you're not going to market with solely a diagnostic necessarily that doesn't have a medical device attached, that doesn't have an additional functionality that just a diagnostic would, right? And that's a major difference. And I think, just understanding that, from a strategic, and here's kind of an opposite way that I like to use it, is early on as a company or a technology, is understanding, one, when you know the IP that's out there, use it to your advantage and understand, Stryker's working on something like this, Medtronic's working on something like that. Maybe here's how ours fills in a gap there. But know, that could be a strategic partner as much as they could be a competitor. So really understanding how to be strategic about what you're filing.
To dig into a little more on that strategy, and then I want to talk to Todd about some of the legal changes too. But just on the strategy side, I'm curious, at what stages do you maybe need to adjust your intellectual property strategy to perhaps address appeal to investors at one stage, appeal to potential acquisition targets at another stage, and to help with your competitiveness in the middle? How do you adjust your strategy for that?
So I think from my perspective, this is the multi-layer strategy. So, on day one, you're forming your company, your patent's going to be very broad, and it's probably not going to cover your final product that you're going to take to market. And so it's developing from a patent strategy. When are you doing inventions? When are you filing patents? Are you using a divisional path or continuation paths? In my particular company, we have two different families that are about 7 years apart. And I call it kind of the genus, which is the very broad claims, and then the picket fencing. And then we went back and filed a completely independent family just in case the first one got invalidated. And that's on the final product as it exists in the marketplace today. And then looking towards, strategics and M&A, the big question for the company I'm currently at is, why didn't anybody else develop it? That's a really obvious thing to have a wireless camera. Like, we all have cell phones, they're wireless cameras. And so now, when we're probably, we're in the first window of when you could be acquired, which is early commercialization. The second window is going to be about $5 million of revenue. We're looking at, how strong are the boundaries on our patent claims? And if somebody, a strategic was going to buy us, how strong would they be in litigation against other companies?
Do others have more to add to that?
Sure. I mean, I think all great points. I think probably the most important point that we see is from that time where you incorporate till you actually take something to market, doing that sanity check to go, or maybe not you doing the sanity check, but an IP attorney saying, do my claims actually support the product that I'm now selling, right? Stuff changes from day one of incorporation to the time it hits the market. So making sure that your claims or your product factually represent what you have protected in your filings.
So Matt mentioned medical diagnostics and how he prefers, if you have a medical diagnostic, that you go more for those apparatus claims than the diagnostic method claims. Maybe Todd, you could tell us a little bit more, especially for the students in the audience. Why is that? How has that changed over the last decade or so?
Yeah, so over about the last 13 years, that has become a must-do because it's almost impossible. You can get a diagnostic patent. It's almost impossible to enforce them now. What happened starting around 2011, there were a series of Supreme Court cases. It started with Alice, which was a business method software case, immediately followed up by Mayo. And those two cases said, under 101 of the Patent Act, yes, it's possible to get a software or business method or medical diagnostic patent, but there's going to be a two-step test. One, are you trying to do a natural phenomenon or mental steps? And if the answer to that is yes, then you go to a second step, and are you doing something unconventional, just at a high level, to kind of transform the mental steps, or a natural phenomenon like a biomarker that's found in the body. The Supreme Court backstopped that with a case called Myriad. Myriad really sunk medical diagnostics because what it said was essentially, we don't care what you do with a naturally occurring gene or biomarker, you're not going to be able to enforce a patent on that. You have to be doing something, and they gave a lot of hypotheticals. It's got to be an artificially created biomarker, but I think where people really moved to was the court kind of hypothetically said, maybe if there's something special about like how you create your sample of that biomarker. So because of that, where things really shifted to is if you're doing a diagnostic, you really have to have the machine you have to have something unique and patentable about the machine that performs the diagnostic. The other thing that I've seen, which can be hard for a startup, because startups just want to check the box sometimes and get the patent, is it's given rise to really trade secrets in this space have become a lot more valuable because, the algorithm that's run on that machine, if you can keep that secret, that may be worth a lot. I took over a case where in Rhode Island, jury verdict came down, the patent was thrown out, but there was trade secret misappropriation. Judge threw everything of that out. I went up to the federal, I took over the case, argued only the trade secret at the federal circuit. got misappropriation of the trade secret reinstated, and then 2 days before trial, the other side caved because we were just going back to do damages on a willful and malicious trade secret misappropriation. And this was on a blood testing device. And all of the science behind the natural phenomenon of this inflammation in the blood, nowhere to be found in anything that we ended up winning on.
How do you balance maintaining that secrecy with some of the disclosure requirements? I understand why you would want to push more towards trade secrets given the Supreme Court cases, especially for things around software or diagnostics. But how do you balance that with some of the disclosures to the FDA or to others?
It's a very tough juggling act, and I think, and this is why I say sometimes it's a little bit difficult for startups versus a bigger, more existing company to sit back and do I'll call it an audit, but just a real deep dive of what's getting sent to the FDA. What do we think? Not what can we get a patent on, because we all know, or most of us know, there's ways to get patents on diagnostics through the patent office. Go to Delaware and get in front of Andrews or Conley and try to enforce them. That's not going to happen. So sitting down and really taking this gamble of what is the classic secret sauce that no one else can figure out, and then making you have to make kind of a hard decision sometimes about do I need to file on this, or am I confident that nobody else can reverse engineer it and I can keep it secret? And it's a case-by-case scenario is what I've seen.
So it sounds like it may be really important to have intellectual property attorneys involved as early as possible in the process, even when startups may not feel like they have the financial capability of doing that, given the long runway for a medical tech device, to tell you, this is what you need to focus on keeping trade secret, this is what your scientists can go and publish an article on, and this is what you go and get the patent on.
Yeah, I think that's really important. And then the other factor that's really kind of flying into this whole, tornado is the Defend Trade Secrets Act has become the Wild West of IP litigation, in my opinion. I'm involved in a case. I'm on the patent side of a Chinese-U.S. dispute, but it's one of the 3 largest trade secret verdicts ever. And it got whacked down from $746 million to $565 million. Some of these trade secret verdicts are massive, and they're typically not going to the federal circuit. So if you're like in the 7th Circuit, they're going to let this thing fly. They're not going to whack a damage award the way the federal circuit will. So I think kind of looking out into the future, if you truly have something that you think you can protect as a trade secret, you might be better off down the road if you're able to enforce that. That can lead to a much bigger reward.
Matt and Leah, how do you balance that trade secret versus patent line when it comes to MedTech devices?
So maybe kind of a comment or open-ended question here a little bit too is, part of my life, which is spent in academic medical centers, thinks they really struggle with the trade secret part, right? I mean, they are not set up to do that. And then it's kind of a conflict because you want the inventor to disclose everything to the office, and then they're disclosing it, and now the office has control. So how do they functionally have the framework to protect a trade secret? And then are they able to translate that to a partner? Which there's a lot of steps in there that may sound moderately hard. I think they're very hard within an academic medical center. And so I think we, from my standpoint, I don't see many trade secrets coming out. I see people saying like, "Oh, well, it's a trade secret." Well, okay, is it really though? Are you taking steps to protect it like it's a trade secret? Are you doing the right things? Where I think we do see it, and I'll just, there's places that we work with, it's kind of in the middle, right? It's this technological information. It's this know-how. How do you capture some things that are know-how, that are process, that are workflow, maybe a little less trade secret, not quite a patent, but somewhere in the middle where it's critical to enable the eventual IP? Leah, go ahead.
Yeah, so I think what I would say is it really falls down to whether or not it can be reverse engineered. So once your product is out there, you can't prevent people from taking it apart and trying to figure out how it works. And so that, from my perspective, that means it heavily falls into software, firmware, et cetera, in the trade secret realm. You put executables on the actual product that goes out into the world, and they can't see your algorithms. And so those are really the fodder of the trade secrets that we're protecting.
Now, we talked a little bit about how I think with the increase in some of those Supreme Court decisions, the likelihood of getting a lot of these invalidated, especially in the software and diagnostic space, has increased. IPRs are the post-grant review at the Patent Office has been one of the big reasons why I think a lot of companies became more cautious about patenting in those spaces because they were getting more and more invalidity. But now some of that may be changing. We've seen, as folks mentioned earlier today, a 0% institution rate for some of the recent decisions. So maybe Todd, you can tell us a little bit more about what's going on there, and then I would love to hear views from folks about how that might impact your business and strategy.
Yeah, so I think I've been doing this almost 30 years, and I think the two big things in my career were first claim construction. So right as I started as attorney, Markman comes down, and there was about 5 years of figuring out how are we going to do Markman before that kind of got settled. And then IPRs were the same way. When they started in 2012, 2013, you had the stats were amazing. You had a 75% chance of instituting, and if you institute, you're in the 90% of invalidating claims. And so, patent law is always that pendulum swinging. So then the pendulum started to swing, back where I think Judge Rader had called it the patent death squad, and he was, maybe voicing like, this is the right way to do it. And you start with the FinTech case where you're now the PTAB, because they were overwhelmed by all these filings the last 3-4 years, we're starting to look at what stage of litigation are you in, how long have you known about the patent? And then all of a sudden, out of nowhere, FinTech moves to what we now call the discretionary denial, which it doesn't seem very discretionary over the last 2 months, where it's if you are in litigation or if you've known about the patent for quite some time, the PTAB is going to deny institution of your IPR as we sit here today. And that, I think it's flipping everything on its head. And, let's see as we come out of the shutdown, is there some middle ground in there? But, right now, I think it's really gone from a tool that was a very good arrow in the defendant's quiver to now you can't even shoot it. And as I said, in MedTech, because of just this huge amount of prior art, I thought that was step one of the defendant's playbook. Is you've been threatened, whether it's a competitor or an MPE, you've been threatened with a patent. Let's go immediately see what kind of prior art, and we'll threaten back the IPR. It'll be interesting to see kind of what happens next with the IPRs, because as we sit here today, you kind of can't do that. So that's what's it's a massive shift in patent law.
Leah and Matt, do you have thoughts on how that might impact you?
Yeah. So I think I look at this a few different ways. One of the ways is if you look at industry right now, and if you're talking to any of these MedTech companies, the majority of them, whether it be Medtronic, J&J, Stryker, whoever, a lot of them have divested on R&D, and that puts companies and early stage technologies in an interesting position. And so what we're seeing from a lot of our early stage companies is they're getting into what's called these build to buy scenarios, where from a very early stage, they're being courted by, or they're courting a large MedTech company. And so what that does early on is that potentially takes, now that you're your return on investment, potentially your return may be smaller because they're coming on earlier, but what you're doing is you're kind of securing some of this early on. And I think, I don't know this to be a fact, but then to think, if you're moving down the road closer to clinical studies and closer, it'll be looked at more of a partnership with these large corporations, these large MedTechs, than potentially turn it into litigation around IP. It may, frankly, become joint IP and development, because a lot of this, I think, what we're seeing from early companies, and it may be, that there isn't quite as much funding, but early development, co-development with some of these partners and looking to go to market together.
More co-development, less spin-off and reacquisition.
Right.
Leah, what are your thoughts?
So, fortunate enough to never had been in patent litigation. To Matt's build to buy scenario, from the company side, what we're seeing is, a number of the companies kind of saying like, we want to advise you on what we're looking at buying in the future, but we don't want you to think we're going to be buying you. Because we don't want that litigation in the future. So you design something exactly what our engineers said we needed, and we decided our strategy that year didn't include you on the M&A. So don't sue us. So I'm not seeing the co-development route that Matt's indicating. I do see that under NDA, these companies are happy to advise what they need.
Todd, have you noticed anything else, or do you think there may be different strategies that will happen perhaps in early litigation as a result of some of the changes to discretionary denials at IPRs?
Yeah, it'll be a race, I think, by both sides now. So instead of, especially if you're, the MPE, are you going to send a letter and offer to license, knowing that your target might immediately, it's in your target's best interest to IPR you very early to get the IPR instituted. So, how does this go? Does the MPE sue first, then start talking? Does the target, we have one client that we've been tracking a set of patents that we know is going to issue later this year, early next. And we have the prior art ready because we know there's going to be a battle. And, hopefully February-ish, we'll have some more insight as to what's going on. But if I'm sitting here today, I'm telling my client, the day after that thing issues, let's throw it into a PGR, which has its own nuances. So, is this just going to be a race to start the fight even quicker? Or is it going to be no one wants to mess around with these patents anymore? Kind of a to be determined.
Interesting. So it sounds like there's a lot of difficulty in how we're going to address things going forward, a lot of uncertainty in this space. Let me shift to a different topic, which is how should you adjust your strategy when you are potentially working with partners or looking to get an acquisition? What should you keep in mind to make sure that you're protecting your intellectual property, your trade secrets? Maybe you can give us some specific tips for people in that environment.
Sure. So, something that is all, I think, a lot of things are very obvious to us in this room, but one thing that we see on a very normal basis is when we're having conversations, let's say with an inventor out of an academic medical center who's looking to work with industry, and we ask the simple question of, who owns it? Like, well, I do. Like, well, we know IP policies and we know how this works. We don't think you do, right? Do you have a waiver? Do you have this? So really understanding at the very basic level who owns your IP, right? And a lot of times most times that can get worked through, but it is something that's very, I think, table stakes, but it is forgotten more than I think most people would like to admit. Second thing is, I think to the point that we were just talking about is making sure that your claims cover your product. That again seems very easy, but it is something that we see a lot where it's a little scope creep and it turns into something where you're selling a product that you aren't actually protecting. And then, I think having strategic filings and really understanding, it isn't necessarily the volume play around how many things you have as much as the content of what's in there. and how someone could look at it from a strategic standpoint. And I mean, there is no doubt the volume piece, when you're talking about continuations and making sure that you're extending the patent life, yes, absolutely, but making sure the content's actually there, providing, because to the point where we were just at, if a strategic sees a generally written or poorly written patent and there's ways to get around it, they'd probably rather do that than have to go the IPR pathway, right? So, anyway, go ahead.
Yeah, just to continue on some of what Matt was saying. On the making sure you own it. And this is, culturally within a company, having IP being important and having the contracts in place. When we're looking at an M&A event, what I've seen when I've been in private practice is they're pulling every single invention agreement with every employee you've ever had at your startup company, all of your NDAs, all of your agreements with vendors, making sure you own the intellectual property. And so paying attention to those details. At a startup company, there's very few people, there's way more work to be done. And, just having that in the fabric of the company. A new employee starts, or we're hiring this individual, this engineer over here to help with one part of design. We always have to check the contract to make sure we're signing it. The other critical part is in the contracts, especially with vendors, it almost always says that you don't own the IP unless you pay them. Startup companies are notoriously always running short on money. So it does actually change some of your prioritization of who you're paying if you're managing your cash.
Yeah, one other thing that I've seen some startups kind of fall down on is not understanding where the potential market can be, especially from a regulatory standpoint. I've seen a couple situations where I've had clients where they want to acquire a startup, and the startup is only filed in the US and blown their European date, and for whatever reason, this product's going to have to launch in Germany first, but you can't get a patent there. You're kind of less desirable now. So I think it's a constant review of just not what the scope of your claims are and do they cover the device, but are you filing in a way that's going to protect the market you're trying to create?
That's a good point regarding international, because the US has this grace period that may not be available for the European filings. And so some folks are just aware of the US law, and they may be releasing publications or other things that may undermine their European claims. Other thoughts?
Yeah, just to that point, right? I think we've all maybe dealt with this, but this is worst case scenario, right? You're working with some inventors who have a lab, and you get a filing that is a part of your strategic portfolio, and something as simple, maybe as difficult as all the inventors being named correctly, right? So it's unfortunate, but we see it where, the head of the lab is the person, they're the inventor, and these other people really had inventive steps or, were a part of the creation, weren't mentioned. It doesn't take much for them to contest that and for that patent to be invalidated. That's a rough way to learn a lesson. So.
Wonderful. Well, I'm sure we have a lot of questions from the audience, and I want to make sure we leave time for that. Does anyone want to start us off? I guess while we're waiting, I bet a lot of students would be very curious. A lot of students, I'm sure, would be curious if they're interested in MedTech. How would they get started in that field if they want to engage in intellectual property and medical technology? Maybe you can tell us a little bit about how you got there while we wait for some questions from the audience. Sure.
Yeah, well, somebody outside asked what my favorite law school class was. I said, never been to law. I learned everything from Rich Wasorek, sitting right in the middle there at the Cleveland Clinic. So I had a very strange way into early stage tech. I was a Navy officer, had an engineering background from the Naval Academy, and fell in love with early stage tech at Cleveland Clinic, and really just started with knowing nothing and taking on everything and being a sponge, to 15 years later running a company in the space by making a lot of mistakes, doing some things right, and then just doing more things right than mistakes. and then surrounding myself with a lot of smart people who, who were similar and open to share and open to teach.
Choosing mentors wisely, it sounds like.
Yeah, so I'll comment. So I started within a chemical engineering degree. The first startup I worked at, I was a senior in college, went straight to case law school, thought I was going to be a patent attorney when I grew up. The job market decided that I was not going to be, so I got a job at Squire in the corporate law department. And that's really where I fell in love with MedTech and startup, is, I was always technologically oriented, and ended up in a job where I could be on all of those deals where it was about technology, and I could do the extra bits of due diligence, like do they actually own the patents that we're buying?
Yeah, mine was a very traditional approach. I started out as a patent attorney and thought I was going to write patents and do opinions, and along the way got dragged into some litigations, did a bunch of trials with, for instance, Jay Campbell was back there, and fell in love with getting up in front of a jury, and just kind of fell backwards, or it was a random walk that got me to this point where I've done about 20 jury trials in my career. And, the one thing that I always hung on to was just having a degree in biomedical engineering. For some reason, as IPRs took off, I started doing medical device IPRs. And that, I guess, that was kind of kept my toe in the MedTech water as I got older. So.
Interesting. I know IPRs are a great way for students. If we continue them, we'll see what happens with the discretionary denials. And what happens with that if that gets challenged. But it's a great way for students to get early experience, I think, or recent graduates to get early experience. All right, so let's open it up to questions. Right over there. Oh,
Thank you. So it seems like there seems to be a growing concern in society that maybe granting exclusive rights to medtech companies might, in some instances, lead to undue harms on some of its target populations. So what's maybe your argument in support of this idea that more defenses and more pens and stricter regulations might be actually helping the target population?
Imagine, especially for medical diagnostics, we were talking a little bit about this.
Well, it's interesting, a little difficult. I'm not exactly sure if there's been a real policy push against this. I think it's really just an effect of the way the case law has come down, where in the 90s, you start with State Street Bank and In re Diamond, In re Tracker Body, where, oh, hey, we can go get software patents and we can get a diagnostic patent conceptually. And then once we got into doing that, I think then there became, oh my God, we're letting people just make these massive moats around much more than they've actually invented. So now we have to cut that back. And I think that's probably really what happened, more than any kind of set policy thing. It was more an effect of, yes, this is hypothetically possible, but the way it's getting put into practice, the patents are way too broad, and so now we have to cut back. And then, of course, it's always a pendulum. So did it cut back too far? I don't know. It's to be determined.
So maybe a clarifying question, because I heard it a little different. Is there an open source part of what you're saying? Should IP not be exclusively licensed, but instead maybe available non-exclusively to more partners?
Yeah, I guess that's correct. What I'm asking, I guess just sort of if somebody was coming to you saying, granting these exclusive rights to these medical companies and allowing them to sort of protect what they've developed and then price it however they choose is hurting people unnecessarily. And if somebody was well, what would be your response to be well, actually excess litigation or something like that if we had these loose pens, might be harming these people? Like, is that the counter argument to that, or?
Yeah, I'm not, from a litigation, I'm not going to come at it from that angle because I'm coming from a different place. But I think, here's, I guess, how I look at that overall is to get most of these medical devices, if not all of them, to market, you need a company, and you need a company who has money, right? So to me, the value here is if you are exclusively licensing this to a company, it's partially because they have the financial backing and support to move these things to market. If you were to give them a non-exclusive license to this, do we think that these would reach the market in the same expeditious manner? I might argue that if I give Medtronic a non-exclusive to something and give Stryker a non-exclusive to something, I don't know that it's going to be advantageous for both of them to go at this full board. Are they going to get the return on investment that's expected? Now, over time, potentially something like that could take hold. But I think right now, when you're exclusively licensing something, and I just think from again, tech transfer standpoint, these things can be written in ways with certain clawbacks as well. So, personally, when we're putting a contract together, we make sure that if it's shelved, we have the right to terminate the contract to ensure, to your point, right? Is this hurting more people because maybe it's getting shelved or something else? Our goal would be, well, if you're not moving this along with certain diligence milestones, we get it back and we're going to go shop it to somebody who will. Not a perfect answer, but kind of tiptoeing around it.
Yeah, I would add all of these technologies, they need two things. They need a champion and they need resources. So when you do an exclusive type arrangement or sell your invention to one company, they get really invested in that thing succeeding. I think if it was more of like the open source, a lot of things would just kind of wither and die on the vine because, why go do this?
Yeah, anything to add on that side?
I think, it comes down a bit to, is the technology worth financing? So med device is much shorter than pharmaceuticals, but the average time between ideation and commercialization is 10 years. So even at a limited burn rate, you're talking, tens of millions of dollars invested in a technology before it ever brings $1 of revenue into the company that invested that money. And so who's going to do that if they don't own the intellectual property to be protected later?
Other audience questions?
Hi. Firstly, thank you all for being here for the great discussion. It was referenced earlier, but what are your guys' thoughts on getting patents in the MedTech space given the PARA, the Patent Eligibility Restoration Act? In the IPRs, I know we talked about that, but what are your thoughts on the PARA Act?
Yeah, I think it always comes back to just what is the subject matter of the patent you're getting, and if you have to be able to get some sort of device, or why are you even doing this exercise? Because you could say, yeah, I found a biomarker, I was able to get through the patent office's flowchart and get it allowed. But everybody out here in the market knows that thing's never going to get enforced. And if it does get enforced, I'm going to knock it out on day one. So I think the just kind of that threshold question that you have to answer is, what am I patenting? And I've got to get this device, into some sort of device or apparatus, or it's never going to matter. It's never going to matter to get the patent.
Right. So one thing we haven't mentioned either that I think is important is the idea of freedom to operate. So maybe you handled the diagnostic piece of that well, and I think part of where what we're seeing from a valuation standpoint, this is kind of going further down the road, or even back upstream, is to say not everything needs a full FTO right out of the gates, but really understanding, going maybe beyond a prior art search and understanding who's out there, what's out there, how does it differ from the different claim language and different things. I think we're seeing more of that up front too, because it's kind of laying out some of the landmines you might face. And frankly, it may deter you from filing early, or it may say, you know what, we won't go down this path with this claim, but we're going to focus in this area, right? So I know that's a heavy expense upfront, but we are seeing people do kind of these hybrid FTOs earlier.
And I'll just agree with Matt on the FTOs. I think it's shifting to informing the development team to how to develop the technology for final commercialization.
I think I saw a question from Rich.
Leah, just a quick question for you as a newcos, coming from your background into this industry. What were the challenges that you guys had to overcome, and like maybe even mistakes that you made that you would advise other people, particularly the IP people here, to advise their clients on, bringing a product to market?
So I guess, I already mentioned that we had to change the name of the company, so that's a clear mistake. But, some of the basic things on IP that I would mention is, like, it's really about the culture of IP. So not in the current company, but I've seen it in other companies, that you're really bootstrapping. You're pulling things together. You have a friend that's an engineer. You all went to school together, but you're not putting the documents in place initially to protect that your company owns the intellectual property and what's ultimately invented. I like to say friends have contracts with friends. So if you don't want to have the conversation with your friend that's helping you invent something about who's going to own it, they're probably not your friend. You're not working together.
Other tips?
Maybe just something, and I'm gonna go instead of a company. I know you didn't ask this, Rich, but just another point is what we've seen a lot recently with large programs inside academic medical centers, and a space that I think needs to get cleared up. And this is a case by case basis, but where tech transfer offices sometimes conflate sort of intellectual property support with business development support, and almost those two worlds are like, well, we have a law firm that's dealing with this client and this IP portfolio, and they expect the IP attorney to be a lot more than an IP attorney. It's then, are we discussing business terms? So, and I think it turns into this, sort of situation where there are some cross lines. So what I see at tech transfer and academic medical center sometimes is being just a lot more clear about what the asks are from all the stakeholders involved. Because I think, and I'm sure that carries over into a startup where everyone needs to know their lane and make sure that they're doing as much possible within their lane and communicating throughout.
I saw another question around here, maybe? And then one over there as well. We'll start here and then there.
Hello. I was wondering if we lose IPRs at the patent office, which appears to be a possibility, what do you think the ripple effects of that are going to be on the MedTech market?
Well, I think it's probably even bigger than the MedTech market. If you're losing your ability to do an IPR, what's going to happen in lawsuits? Certain districts have automatic stays if you file an IPR. Other districts have a stay if it's instituted. You're going to have a bunch more cases that are going to be fast-tracked and moving very quickly. So what does that tell you? Invalidity is going to be much more important in litigation. And I can tell you my experience, it's a lot easier to do an obviousness argument to the PTAB than a jury. So I think, just it doesn't matter what kind of patent you're talking about. Obviousness, if IPRs go away, obviousness may go back to the stepchild role that it's traditionally had. I think that you'll see that right away. The other thing you may see is if you're an uber aggressive potential defendant and you've got good prior art, good anticipatory prior art, do you DJ somebody right away when they threaten you and try to force their hand? That could be another thing that happens. I don't think it's unique to MedTech. I just think that's going to be a patent litigation issue.
And it's obviously easier to address those obviousness concerns when you don't have to balance countervailing infringement analyses as well.
Yeah, and you're at a lower burden, so it's just all the way around. If that goes away, I'm not going to say goodbye obviousness, but obviousness is really hard in front of a jury.
Absolutely. Question over here.
Yes, and thank you all for being here. I know that in Europe, you, at least I believe, you can't really patent claims that involve the human body. And so I was just curious if those different eligibility standards around the world are things you're really thinking about and counseling clients with, or if it's just like most of the markets here in the U.S., and if you're not eligible in the U.S., forget about it.
Well, my starting point advice is you got to do a medical device claim. So if you do a medical device claim, you're going to be okay whether you're U.S., Europe, China, Japan. If you don't do a medical device claim, you're going to have enforcement problems in the U.S. and you're probably dead in the water overseas. So, the bottom line is do a medical device claim if you can.
Yeah, and I think coming from commercialization advice, that needs to be a very early market analysis that's done. That's essentially, because that becomes one of the most expensive parts of taking this to market from an IP standpoint is, all right, you're past the U.S. Now where else do you file? Well, you're not filing just to file in foreign countries. You're filing because you think there's a good market there. You think that your strategic partners want to do business there. Because the worst case scenario is you take something to I'm trying to think, not Teleflex. We'll think of a German company who does a lot of work in certain European. You want to make sure it's covered in different places, right? And so, but you need to have the market numbers, the TAM, SAM, SUM to understand. Is this going to be prohibitive or is this going to be advantageous for you? And then it drives. Because, as a startup, you're not wanting to spend on any foreign litigation or foreign filings that you don't have to, right? And then take that all the way back to the academic medical center where it's all starting out. You may not be getting things out of a Cleveland clinic that have a ton of foreign filings if that interest wasn't thought about up front.
Great. Any final thoughts before we wrap up the panel? No? Well, thank you so much, all of you, for joining us. Let's give them a round of applause. Great, thank you. So we'll switch over to sports. It'll take us a few minutes to set that up. So he's been a huge, huge help. And Ari Stern's worked with brands and athletes and independent inventors for nearly 20 years, protecting their brand's ideas and innovation. He's a former drug-free weightlifter, an American Open record holder, two-time national collegiate gold medalist, and was a member of the national team that trained the UMS Olympic Training Center. He was awarded a presidential commendation for his anti-drug efforts, speaking to athletes and coaches throughout the United States and Europe. He earned his undergraduate degree in biological sciences from Ohio State, master's degree in anatomical studies from Case Western Reserve. Currently, he is the general counsel of Sportech, and proud alum of Cleveland State. And then I'll also have Eric come on up, one of our students, who's going to introduce some of our other panelists before Ari jumps up.
Great. Thank you, Krista.
Thank you, Ari. Thank you, Professor Laser, and thank you to our panelists who I'm going to introduce now. Ricky Vellante joins us from RVIS Media Partners and Vellante Law Firm. With considerable experience as a CEO, co-founder, attorney, and partner in the sports and entertainment industry, Ricky has a unique and comprehensive perspective on the legal, business, and creative aspects of these fields. Next to Ricky is Bennett Spire. Bennett is partner and co-chair of the hospitality, leisure, and sports industry sector at Shoemaker, Loop, and Kendrick LLP. Bennett has built a practice counseling elite college and professional coaches, athletic directors, and conference commissioners, as well as executives in the sports and entertainment industry. Next to Bennett is Andy Sims. Andy Sims is here from One of One Agency and represents over 50 current NFL clients. Andy started as an agent by signing minor league baseball players after year one of law school. His practice areas also include contract negotiation, financial services, marketing, and post-career counseling. Ken Feinberg is president of Power NIL. Ken is a transactional attorney and entrepreneur with 30 plus years of experience in complex contract negotiations and NIL consulting, compliance, and marketing. And last but not least is Gregory Vincent. Greg is CEO of Vincent Strategies and owner of Gregory J. Vincent Law. Greg served as vice president and professor of law and education at the University of Texas at Austin. Part of his portfolio is the University Interscholastic League, or UIL. The UIL was created by the University of Texas at Austin to provide leadership and guidance to public school debate and athletic teachers. Since 1910, the UIL has grown into the largest interschool organization of its kind in the world.
All right, great. Thank you very much, Eric, and good morning. This is amazing. Kudos to Krista. We have about 125 people in person, 175 online, and this conference continues to grow every year. I am Ari Sherwin from Sportech. I haven't said those words in nearly 20 years, as I was in private practice for a few years, and I was in-house counsel at Sherwin-Williams for nearly 15 years. But I'm back to my passion, and that is working with athletes and independent inventors. My first mentor, Sal Sidoti, is here as well. And I never saw a patent before I worked for Sal in Westlake. That's when I was living in University Heights, and I had to schlep over there. But now my wife and I have to take our 14-year-old son every week to Valley City, Ohio. I never even knew that place existed before he was recruited by a baseball team. And nice to see some of my colleagues here from Sherwin-Williams. But now we're going to have a little fun with this session. Not your typical IP program. We'll be talking about a lot of topics related directly, ancillarily, tangentially to intellectual property involving sports law. So let's start off with this company, this brand, probably one of the biggest in the world, has generated billions of dollars, goods and services sold in over 200 countries, and its flagship product was invented in the early 19th century. Can anyone tell me what that brand is, that company is, by raising your hand? Related to the sports world. One of the biggest brands out there. What's that? In the food and beverage industry. Close. Keep on going. Carbonated. Yeah, Coke. I'll give it to you. Nice, Mike. Coca-Cola. And one of my favorite quotes about Coca-Cola is from a book my son actually had to read during summer reading. 1 billion hours ago, dinosaurs roamed the earth. 1 billion minutes ago, religion was created. 1 billion seconds ago, the Beatles changed the music scene forever. And 1 billion Coca-Colas ago was yesterday. Branding is everything. And you'll be hearing from our panelists, a power-packed panel of panelists relating to branding, endorsements, sponsorships, and other topics that relate to intellectual property. And up until a few weeks ago, I was planning on leading off this panel discussion about NIL. It's all the rage, except for the fact that during the past 2 weeks, sports betting and gambling has taken over the scene, especially since some of those players involve former Cleveland athletes, like Damon Jones from the Cavs, and Cleveland Guardians pitchers Emmanuel Clase and Luis Ortiz, who were indicted and are being indicted on charges relating to rigging, sports betting, and gambling. So on that note, I think we should start with that topic. And we'll start with Ricky Volante, who played baseball in college, stopped playing, not because of gambling, because he tore his UCL. And early on in his legal career, he was involved in an entity that was one of the first involved with launching sports betting in Ohio. And I believe you also dealt with the Ohio Lottery Commission as well, correct?
That is correct.
Tell us about it.
Yeah, so I was legal counsel for one of the Type C proprietors in the state of Ohio. I believe that we were either the first or the second to market with betting kiosks all throughout the state in various bars and grocery stores and things like that. So we dealt with the Ohio Lottery Commission, Ohio Casino Control Commission in terms of what bets were allowed, how much you could bet on a given day, which were much more restricted than what you could do on your phone, which felt a little counterintuitive, because if the restrictions are so high for someone to have to leave their home, go to a restaurant, a bar, a grocery store to place a bet, they're clearly making a lot of decisions along the way. Whereas if you're sitting in your house and pick up your phone and you can basically bet unlimited amounts of money, that could lead to considerable problems, as we've seen, not on the field, but off the field, in terms of these are usually people that are living below the poverty line or right at it that are making these bets. So it's people that can't truly afford to bet. So, in my opinion, it's been incredibly problematic in a lot of different ways. And given what we've seen with Damon Jones and Clase and Ortiz, it's certainly hit Ohio in a number of different ways on the field as well.
All right, thanks. Now let's address some ethics issues with Ken Feinberg. And when he's not practicing law at Power NIL, Ken likes blogging about pizza. He's been to over 100 pizza establishments in 16 different states, right?
Yes, sir, since COVID.
Very nice, since COVID. All right, well, if you could chime in with respect to some NCAA concerns in the sports betting gambling arena, we'd appreciate it.
Yeah, absolutely. So in 2023, I was at the College Sports Commission conference in Las Vegas, and Charlie Baker, who's the president of the NCAA, was there. One of his big hot buttons at that point was gambling on campus. So some statistics that I think were concerning to him, around 70% of students on campus are betting, and in some cases they're losing up to around $500 a day betting. So this became a real concern of his. And the biggest concern he had is what's known as a proposition bet or prop bet. And what a prop bet is an individual bet on what an athlete will do or not do in a game. So for example, who will be the first player to hit a free throw? Who will be the first player to miss a free throw? And things like that. And the reason that was a concern to him is because of the pressure it puts on the college athlete in terms of manipulation, performance. They get harassed if they're by bettors who lose, if these things don't happen. So he started lobbying states to make prop bets specifically illegal. And he's had success in 13, including Ohio. So those bets are now illegal in 13 states. And by the way, the NCAA is the only sports organization that doesn't have some kind of a partnership with a sports book. So he's had success with that. The NCAA does have a new policy that's coming out next week, I think the 22nd, that is permitting gambling by athletes and by people in the athletic departments only on professional sports. So there will be no betting that's permitted by a college athlete on a collegiate sport or somebody within the athletic department on a collegiate sport. That's going to happen next week. So he's had some success. What he's trying to do is balance the fact that most students can bet, but athletes can't. So let's try to find some compromise while protecting the integrity of the sport, and hopefully he's found it.
All right, great. Thanks, Ken. So we'll segue into NIL, name, image, likeness. And this is basically an area that intersects with trademarks, trade dress, copyright. And speaking of which, that's why I also love Coca-Cola as a demonstrative. And by the way, who said Coca-Cola? I think maybe just slightly before Mike Vetrick did. It came from this area. It's the honor system. We're getting ethics credits. There you go. The reason why I like Coca-Cola for emphasizing the aspects of IP is that it's all in there. All 5 main areas of IP. And I think of it as the abbreviation PCTTT. PCTTT. P for patents, C for copyrights, and the T's, the 3 T's, trademarks, trade dress, and trade secrets. And Coke has it all. Patents they have on bottling procedures, copyright design for the hobby skirt look of the bottle, the trademark, the name, Coca-Cola, used to distinguish it from other goods and services. Trade dress, the compilation of the color scheme, the collective verbiage on the bottle and promotional products. And then trade secrets, the beverage itself that is kept a trade secret. And that's why it's such a great example. But with name, image, and likeness, a lot of individuals are profiting, commercializing from their voice, from their facial features, from their overall body persona, via contracts, endorsements, sponsorships. It's very hot now, not just with pro athletes, college athletes, but even high school athletes. And we've heard of some of these deals that are crazy. Of course, with the high caliber athletes like Cooper Flagg in basketball when he was at Duke making $4 million. Jeremiah Smith at Ohio State, receiver making $4 million. But how about some of the women out there making a lot of money in, quote, no name or amateur sports like gymnastics? Anyone know the gymnast from LSU by raising your hand? Yeah, that's right. Was that you, John? Who said it first? I trust you. Go ahead. Olivia Dunn, exactly. $4 million as a gymnast. She'll never make that much after college. Recently, there was a teen softball phenom at Texas Tech, just signed a $1 million contract as a softball player. It's nuts. But that's what it is today, and a lot of people are jumping in, and plenty of intellectual property issues involving NIL. So Ken, if you could please, before we jump to the others, can you just briefly give us kind of like the anatomy of an NIL deal?
Yeah, sure. So, no shocker. The most important part is having a client, whether it's an athlete or a brand. So once you have that, then let's assume it's the athlete that's the client. Empower NIL will have brands or athletes, but then it's a matter of trying to find an NIL, I'll call it an NIL match, and they're coming to two different buckets. One is the rev share bucket directly with the institution, and the other is endorsement deal with a brand. Once you can identify one or the other of those, and by the way, it's far more complicated than that. I'm just trying to keep it really high level and simple. Once you find a partner, so to speak, then it's a matter of getting into some kind of negotiation and coming up with a contract. From there will be compliance issues in terms of disclosures with the university or disclosures. Now there's a portal that's being managed to keep an eye on the rev share component of it. It's nilgo.com, which is a oversight. The oversight there is by Deloitte. And again, you can have institutional reporting requirements. And then once that clears, then you have the execution of the contract, meaning the deliverables. What does the athlete have to do to earn the compensation that they're being paid? Very high level.
Great, thank you very much. And by the way, I'm trying to give away some more of those Sherwin-Williams Browns co-branded painter's caps. I have 300 of them, so I'm slowly getting rid of them, which, by the way, I didn't collect while I was at Sherwin for 15 years. I bought them about 25 years ago when I was presenting at schools at before Mark's at Bernie Schulman's. So slowly getting rid of them. Thanks, Ken. Let's hear from Greg Vincent. And Greg was kind enough to drive up this morning from Columbus. He also had the opportunity to see some stars in action when they were in high school, including Browns player Myles Garrett and former Browns quarterback Baker Mayfield under Friday Night Lights. Thank you for making it up here. We would love your perspective with respect to the institutions, the executives, and the nonprofits involving deals such as NIL.
Well, Ari, again, it's an honor to be here. I taught my second CLA class here at Cleveland State 30 years ago, so it's fun. It's an honor to be back.
All right, welcome back.
Welcome back. Thanks. So you heard just a great synopsis of the art of the deal, but I just want to just take us back to kind of the origin of this. And, for almost 30 years, almost close to 40 years, the case that ruled all of this issue was a case out of Oklahoma, right? Oklahoma versus the NCAA, and basically said that collegiate athletics was amateur, and you could only get your basically your cost of attendance, right? And that's kind of where it was. And so this is a seismic change, the Alston case that was rendered by the Supreme Court in 2021. So for almost 40 years, this case ruled, and it completely changed the way we look at compensation. I'll think about another great Northeastern, someone you may have heard of, LeBron James. I don't know if any of you all heard of him, but just imagine what his life would have been like if these NIL deals were in place at the time, right? So, and we saw that I think they claimed he got a car. I think about Reggie Bush and the USC situation where they took away his Heisman and the Fab Five. And so this is just a seismic change. And candidly, when I was teaching in this area, I really thought that labor was going to be the huge issue, the Northwestern GA cases and the student athletes. But boy, to see this take off was incredible. And I think part of it had to do with how stubborn the athletic directors were. So I worked very closely with athletics when I was at the University of Texas at Austin, as well as at LSU. And even though those departments were making millions, hundreds of millions, the reality is they felt that we did enough for the student athletes. And I think that pressure to change that, basically we're making millions for the university and we're not seeing anything from it, and then being held accountable when they were offered opportunities and even being penalized in the case, for example, in Reggie Bush, being his Heisman being taken away. So this is in my lifetime, it's been amazing to see how this area has evolved. You mentioned women's sports. I do believe you're going to see a huge influx of money for women. I think there's great interest. That softball player, her name escapes you right now, but I never watched softball before, but I watched her. And I know many others did that as well. Of course, gymnastics as well. So I do think there's a seismic change. You also asked me, I don't know if you want to wait to talk about high school. Although Ohio is going to make their decision later this month with the Coaches Association, so we'll see what happens in November. In Texas, the NIL is still prohibited, one of about 5 states that still have that prohibition. So I think that's going to be interesting to see. But in 46 other states, as long as it's not affiliated with the school, student athletes can benefit from name, image, and likeness. And so it is a whole new world, and it's accelerated since the Alston case in 2021. And we anticipate even more changes in the coming years.
Thank you. And by the way, if anyone can name that Texas Tech softball player, you're getting 299 Sherwin-Williams Browns caps. Going once. You got to pick them up, though. Twice? 3? I think it's Janae Canady. And I'm looking forward to watching in the spring during the Women's College World Series. Andy Sims from One Agency. Andy signed his first NFL client draft picks when he was in law school. And now he's teaching sports law at Case at that same law school, kind of came full circle. Give us a little perspective on representing players.
Sure. First of all, thank you for, it's an honor to be here. And honestly, the guys on this panel, I was thinking about, not sure I deserve to be here with these guys. There's a great background in what these guys are doing. My perspective is somewhat unique. I did start doing this, I guess this was back in the late 90s. This whole business that I got into in representing NFL players and seeing them through the draft process, doing their contracts, guiding them through their careers, the landscape is different. The job is the same. We do the same things today for the college guys and now seemingly high school. So what these guys are talking about, it used to be I would meet guys and the rules were very specific. I could talk to somebody who was draft eligible, basically a senior in college, and there were rules through the NCAA, through the states, through the NFL Players Association who we're registered with. And with that, I couldn't give if I was recruiting a senior, I couldn't pick him up in my car. I couldn't pick up a $2 coffee for him. And there's so many rules that were in place, and we're so ingrained to not deal with all of the, you just wanted to stay clear of it and make sure you did everything right. And now the rules are changing. So as I mentioned, the landscape is changing. The job's the same. we now do the same things today for kids in college. We're negotiating their deals. And I know this was touched on here by Ken, but the NIL, as I think we thought it was going to be, is there. But this revenue sharing, where players are earning salaries and now directly paid from the colleges, that I don't think, and maybe other people can disagree, I didn't foresee that happening this quickly. And so there really is that revenue sharing component where, as agents, we're negotiating the college salaries for the player. And with that, there is an NIL component also. And so these colleges for football, for basketball, and for other sports are finding ways to not only pay the players under the revenue share, but also finding creative ways to pay the players through approved NIL and finding deals for them. And so as an agent, I need to work with the colleges in that way, but also we have our own marketing team that would work with our NFL players, find them endorsements, do things like that. And now we're doing the same thing for colleges and apparently for high school guys now too. So, you know, our business is expanding in some ways because there's more opportunities to be working with, a large number of new clients. But it's definitely different. I hit my first high school game this year, and I thought that was something I would never do. So it is a changing business, but it's something that's been, kind of fun to keep up with.
Yeah, definitely. That's why I love my job. It is changing, and the numbers are staggering. You have college players making more than their coaches. You have high school kids making more than their parents. And a lot of these people aren't just doing the NIL deal for the money, but for swag. They have ideas. They have inventions to protect with patents, trademarks, copyrights, to sell, to license. I worked with an inventor who was one of only 2 people ever to license a patent to Nike for a sole. And he didn't approach Nike. Nike came to him after his patent was granted, and probably after Nike determined there was no way they were going to be able to design around that patent. And that's how that deal was done. A podiatrist turned weightlifter, and that's a story for another day. Bennett, reformed ERISA tax attorney, now representing clients from coast to coast. I'd like to get your thoughts on a huge topic, the buyouts. And a couple of years ago, former Texas A&M coach Jimbo Fisher was paid $77 million after he was fired. And this year has been a record for buyouts, and I'd love for you to delve into that and tell us kind of how those buyouts work contractually.
Sure. Thanks. Great to be here. And also to be, I actually started my career in Cleveland down the street at the Huntington building in what was Ernst and Winnie's tax department. I know they've relocated and merged right after I left, but and that was actually my first exposure to deferred compensation. I used to do the tax returns, the partnership returns for the Cleveland Indians when this was before the Jacobs bought the team, and so I get the file dropped on my desk, prepare the return, and there was a deferred comp schedule, and it was 2 pages long. These were players that hadn't played in years but were still being paid. So that ultimately became a big part of my practice. Initially working with closely help business owners, professionals, and we were always trying to take money off the table pre-tax, because you never know what's going to next year is going to bring. You don't have a crystal ball. Through a connection to a financial advisor back in 2007, I think it was, who was working with an elite level coach. We just identified that the coach was receiving some off the W-2 income directly from Nike. That's how a lot of those deals were back then. And so I did what any ERISA attorney would do and set up a defined benefit plan to shelter that. And just one thing led to another. And just one point I wanted to add about, we were talking about NIL. I think one of the pressure points, or part of the context for student athletes to be compensated, was the acceleration of coach compensation. We talk about the schools are making a lot of money, but the coach compensation just skyrocketed. One of the first coaches I worked with, Rich Rodriguez, this is back in 2008 2008, I believe, they had he had just turned down Alabama. I don't know if any of you remember that. In fact, I still work with Rich to this day, and he says, they should build a statue for me in Tuscaloosa. And why is that? Because who'd they end up hiring? Nick Saban, right? But I think the dollars back then, 1.2 million in West Virginia, up the ante to 1.8 because he turned down Alabama. That's like a month's pay now for the Kirby Smart. So that's how big it's gotten. And with that, coaches have obtained huge guarantees under long-term contracts. And this is a record year. It's probably going to hit 200 million. There's still a number of coaches on the hot seat. So it could easily get to 250 million, depending on what happens with schools the rest of the season. Ari mentioned taxes, and I think we read about all the big numbers, but I think one thing that doesn't get written about, especially for law students and tax classes, kind of interesting to learn is that there are a lot of tax ramifications with these buyouts. So you mentioned Jimbo's buyout. Now, most buyout provisions, and by the way, buyouts is it's a colloquial term. It's liquidated damages. So anybody who's had contracts won understands what liquidated damages are. They're enforceable as long as they're not a penalty. So the liquidated damages that Texas A&M owed to Coach Fisher when they terminated him was $7.5 million a year for 10 years, $75 million. He didn't even have a duty to mitigate, and A&M didn't have a right of offset on that. What I think surprised, so I worked with A&M on kind of that whole exit, and I think probably something that was a surprise to Jimbo and his team was that you don't get to pay the taxes as you receive the money in that context. If you're a tax exempt employer, which include a school, state school like A&M, if you're an executive or whatever, and you have the right to money in the future, and it's not subject to what's called a substantial risk of forfeiture, in other words, it's not at risk, then there's a tax code section 457F that says it's taxed as soon as you're vested, the present value. So right up front, he had probably 75 million was owed to him. Let's say 65 was the present value of it. He had to pay tax on that 65 right up front. And then, one other cost that hits most schools, not all, I won't get into that nuance, is so when a school pays this buyout, it's not just what they got to pay the coach, they got to pay the government too. Back in 2018, a new law became effective, and this applies to, all nonprofits and most state institutions. And it's an excise tax on what's referred to as excess compensation. So any coach, up until recently, if you were if you were one of the top 5 paid employees at one of these schools, and you were paid over $1 million, the school would have to pay be responsible for a 21% excise tax on the excess comp. So if your coach is paid $2 million a year, it's going to cost the school $2,210,000, right? 21% on the excess. Well, with buyouts, that tax gets accelerated, and that is because there's a provision that refers to excess parachute payments. So if your buyout is more than 3 times what the average was of what you made in the preceding 5 years, then the difference between the present value of those future payments and that 5-year average established before that is all subject to a 21% tax right up front. So
thanks, Mark. No, appreciate the insight.
Yeah, hey, Ari.
Yes, go
I
ahead.
just wanted to just pick up on two
Please.
quick things that Ben had shared. Just this acceleration you mentioned of coaches' salaries. Had the honor to work at LSU when we hired Nick Saban, in 2000, and we paid him $1 million. And that was big news. And you know where the dollars are now. So this, even in a quarter century. The second thing is how even individual donors, I'm thinking about Phil Knight at Oregon and other places, are bankrolling in large part these athletic departments. So that's another factor. Or collectives, of course, that we talk about. And SMU just stands out, right? Because, of course, perhaps the first school, well, CCNY, but to get the death penalty. And now they bought their way into a Power Four conference. So those are two dynamics that I think are really rearing up today. Right?
No, thanks for that add-on, Greg. Let's change gears. Related ancillary industries like entertainment and film. In the audience, we have Ray Williams. Ray, can you stand up? Ray is the star of a documentary called Mr. Football. You may have seen this documentary, distributed by Apple, Amazon, and Google, produced right here in Cleveland at Trinity Studios. Howard Pearl in the audience has been involved in the film and other types of entertainment, even pet industries, working together on other projects. You got to check it out. It's an incredible documentary, and it involves not only Ray, but the Benedictine Bengals championship team from the early 2000s and a tragic killing that took place. Speaking of football, David Mays, are you here? I know he said he was on the way, but David Mays is a former Cleveland Browns quarterback, hence the football. And the next trivia question. David Mays was brought in when this quarterback went down against the Steelers. We were losing. It was 1976. And Mays came in to replace this quarterback, if you can raise your hand and name him. And David ended up winning the game against Pittsburgh in 76. Anyone want to take a guess as to who he replaced by raising your hand? Not you, Ray. Brian Sipe. Nice. All right. So with respect to the entertainment and film industry, Ricky has been involved with the Greater Cleveland Film Commission, and you also battled the NCAA, right? Worked with David West, NBA great with the Golden State Warriors. Tell us about it.
Yeah, so I'll start with the college sports side. I definitely come at it from a different perspective than the rest of the panelists in terms of most of my work has been advocacy based on behalf of the athletes. I've done NIL work, but we were part of a group originally, and to condense nearly a decade's worth of work, we originally tried to get the HBCUs to break away from the NCAA. If you don't know what an HBCU is, it's a historically black college and university. The HBCUs were once the powerhouses of college sports, primarily due to segregation. And then once college sports was desegregated, many of the black athletes started going to bigger schools at that point. And what we were trying to do was both compensate and educate athletes and use the HBCUs as partners in that venture. In addition to all that, we were working with various different congressional efforts. I remember when Condoleezza Rice put out her very poor report on the future of college sports. We spoke with her, tried to let her see the light a little bit. Unfortunately, her perspective was that college athletes getting an education was good enough as far as compensation goes in her eyes. Most of what you see today in terms of talking points, and this even happened, I believe it was yesterday, when the president joined Pat McAfee to talk about how college sports is getting out of control. If you'll entertain me here for a moment, I'm going to read a headline from the New York Times. I'm not going to read the whole thing because apparently brevity was not a thing at the time. College sports tainted by bounties. With the commercial, sodden with the commercial, only 28 institutions were cleared. They studied 130, and that ultimately college sports are tainted. Does anybody want to guess when this headline was written? 1929. They found that of the institutions at the time, 130 studied, 102 were paying their athletes directly. This is not a new thing. It is not something that these institutions have not dealt with. In fact, if you go back and look at the time, Yale, Princeton, Dartmouth, those types of schools, primarily the Ivies, were the football powerhouses. They were the original super stadiums throughout the country. They were the ones that were pushing 100,000 capacity in the early 19th century, early 20th century. And the reason was, I'm sorry if I'm going to offend anybody who may be an Ivy school grad here or alum, they paid the most. It wasn't because people wanted to, these athletes necessarily wanted to go to those institutions. It was because they paid more than everybody else. And ultimately, that is what drives most decisions. And it's interesting to see how, again, everything's cyclical. It comes back around. We have really bad legislation that's out in Congress right now that would try to not just rein in compensation directly to athletes, but also potentially put the genie back in the bottle on NIL. At least some senators want to see that happen. So, I've extensively worked with state officials, with House of Representatives and senators and in particular, Senator Chris Murphy, with his efforts to push the envelope much further in terms of these athletes are labor. They should be treated as such. Even with this current revenue share, a cap is still a cap. If you go from here to here, it's still a cap. That was not negotiated at arm's length between two parties, which is what happens in professional sports. Again, a talking point that many conservatives in particular are using right now is that U.S. professional sports have caps. Those caps were negotiated between a union representing the athletes and the league's office and their respective owners. The athletes don't have a voice in this process. There is no representative entity or institution for the athletes in this process. There is an organization called athletes.org. However, if you scratch the surface and look into its founder, Jim Cavale, you'll see that he still maintains an ownership interest in Influencer, which Influencer is hired by the institutions to help them run their NIL programs in some instances. So again, I come at it from a different perspective, but I think what we're dealing with is a continuation and an attempt to take away rights that if you or I or anybody else wanted to go and sell our name, image, and likeness or earn compensation to do whatever it is that we do, in case most people in this room being attorneys, we're free to do so. But the moment that it becomes a college athlete, apparently people have problems. So with that, I'll get off my soapbox.
It's an intellectual property conference. So actually, Ken, any unique, weird IP issues you've encountered during your practice?
So I think one of the first deals that I did was we were representing a custom men's clothing store in Lexington, Kentucky, and they were looking to partner with a UK football player. So they identified a player. I reached out, and before I get to the trademark issue, the first scary moment was when I asked him if he had a representative that I had to contact to talk to him, and he said, "Yeah, my mom." And I'm like, "Oh gosh, dealing with a mom representative, that's scarier than any lawyer." Turns out she was very nice and it worked out well. But anyways, the trademark issue is this. The clothier and the player had this bright idea of lining. He was going to make a custom suit for the player, and they were going to showcase it at the Lexington equivalent of the Kentucky Derby, which is known as Keynote, if anybody's familiar. So they were going to do a whole photo shoot at Keynote, and that's why the custom suit, value of the custom suit, maybe $3,500, right? They came up with this great idea to put the UK logo in the lining of the jacket. They thought that would be really neat to do that. So it's like, hold up. One thing that the universities protect with regard to NIL is their intellectual property very strongly. So you have to go through the red tape to get permission to use it. And by the way, in the Ohio law that's probably going to get voted on next week, that's one of the components where you can't use your high school trademarks IP. Anyways, I reached out to the University of Kentucky with this idea, and of course, at big universities, it's a bureaucracy and a complicated corporate hierarchy. They usually outsource these type of things. So I had to deal with two companies, JMI Sports, who's their MMR, multimedia rights company, and it's not Fabletics, Fanatics,
who is their licensing agency. And I reached out, and they wanted to know what we were proposing, and they said, yeah, you're gonna have to pay for that. And I said, are we talking $100, 100,000? What are we talking here? And they said probably 5 figures to do the lining with the logo. It was a $3,500 suit. Nobody was going to pay 5 figures just to have the right to do that, so it died. So the important thing, I guess, to take from it is that with regard to IP and with regard to facilities, the universities are very protective of that.
Thanks, Ken. And actually, I just remembered a client I tried to bring into Sal's firm when I was a young IP attorney, an athlete who, you may remember this. What are you going to do, fire me? Young athlete developed a libido product, and you were asking, oh, is it chemistry related? Going to get a patent? No, it's trademark. What's the brand going to be? Resurrection. You're like, we're not taking it. And I think there was going to be a cross on the packaging as well. All right, let's talk about a little bit about crisis management. Andy, how do you handle dealing with the media, especially with matters that involve tragedies, privilege? I remember reading that you represented a wide receiver, Chris Henry, who tragically passed away mid-season. Please elaborate.
Yeah, I mean, I would say one of the biggest headaches of our business, what I deal with, is the media in general. I'll get back to the Chris Henry thing in a second, but dealing with the media, the entire dynamic of the media trying to get information, that Adam Schefter's, the Ian Rappaport, so whether it's NFL Network, ESPN, whoever it is, there's a race to get information. And this isn't just true in sports, obviously. It's putting out information first. Who's breaking the news? And everybody wants to break the news. And it could be a local reporter. So I get so many messages and calls from reporters looking for information. And at some level, I could say I just don't want to deal with it. But the problem with that is there's a use for them too. You do need to be able to put out valuable information at times. Sometimes you need information. This gets sort of to the crisis management time. There are times when you do need the media to put something out for you that's important, relevant for your client, something that may be helpful for you. The media is a real tough component. And I guess it was 2009, I had a call. I was actually on the road. I was recruiting. I was just outside Pittsburgh, and I had a call from Marvin Lewis, who was the Bengals coach at the time. And he's like, Andy, what are you up to right now? What are you doing? I said, I'm just leaving a meeting. How you doing, Marvin? He's like, well, you may want to pull over for this. And he told me the news about Chris Henry, and he had tragically fallen / thrown / pushed, whatever it was. He died falling off of the back of his truck. He had gone home for the bye week, or he had a couple extra weeks as he was an injured reserve for a short time. Got in an argument with his fiance about, of all things, like a wedding invite list. Long story short, he passed away. This is in season, and this is not something that as an agent you're like, oh, I got this, right? Like, what do you do? So we needed to, I'm getting calls from all the media, and then I'm also trying to figure out, like, his fiance, who's, they've got kids, he's got a fiance, like, she's also, unfortunately, there's a pending, criminal investigation. And so, just dealing with what information to put out there, dealing with the team, players' family. Ultimately, I think this was really the infancy of Twitter also. I think 2009, I remember putting out a statement, because before that you would call the AP, or you'd have to put something out differently. And I remember getting that out there, and we put out a statement, and it ended up, kind of covering the bases. But the media is always a tough one. And when there's things you don't know yet, or you don't want to put out yet. And then I'm dealing with the Cincinnati Bengals and their PR department on what they want to put out, because now they got to figure out how they're going to handle this in season, a funeral during the season, which they did a fantastic job, by the way. It was outside of New Orleans and his hometown. But yeah, dealing with the media in general, that was a real learning experience for me. I've had many players since then. I don't want to say many, I look like a jerk, but who have gotten in trouble off the field. Things happen. And so dealing with the media is, I find more now than ever, less is more. We with social media, we don't always need to comment or get involved or give a story legs that maybe didn't have it or maybe won't have it. The news cycle, everything goes so quick. You know, something seems so bad, or you know, if something happens to a player and it's like, you know, it's their whole world, right? It's everything. And 24 hours later, no one gives a crap. Like, it's over. It's over. It's done. We move past it. So a big part of our crisis management at this point is like, just don't talk about it. Let it go. Say nothing. And that is so often the case. But, you know, sometimes it requires more.
I appreciate that, Andy. Greg, you've argued a couple of cases before the Ohio Supreme Court involving the Civil Rights Commission before the age of 29, correct? So if you could please, before we take some questions from the audience, what's being done or what should be done to ensure fairness with respect to race, ethnicity, gender, etc., in the sports world or elsewhere?
Yeah, Ricky, you just shared some things that really resonated with me about just how recent this issue of integration occurred. As I mentioned, when I was at Texas, the University Interscholastic League, which was the last university-sponsored school association, was part of my portfolio. But until 1970, they were segregated. The Prairie View League was for the black players. And players that you know well, Bubba Smith, me, Joe Green, they all came up through the PVIL, right? And so this issue is still very much present. Our NIL client is Howard University, which is a Division I HBCU institution, and trying to figure out what is going to be their unique brand, right? Is that social justice? What is that? You know, what does that look like? You know, as far as justice goes, I'm going to take two tacks. One is gender equity, right? How do we ensure that Title IX is fully addressed? Thankfully, as someone who was a student athlete when Title IX was just starting, it is amazing to see how much that has, how that's changed for the better, although there's still a long way to go. So I'm really excited to see some of those issues. We don't have enough time to deal with the transgender issues. One of my alma maters is the University of Pennsylvania, and they were kind of put in the bullseye around transgender issues. So that's another thing that we don't have time to get into. And as we're on the Ivy League, we should know that the Ivy League was started as an athletic conference, not this academic thing that whatever that might be. But as it relates to race, we still have huge, we've made huge progress, and we have a good way to go. When you add socioeconomic status, that is a real challenge. When you think about the young men and women who were embroiled in these pre-NIL issues, it was around, I want to support my family. Someone was going to put money in my pocket, right? That's what it was. And in many instances, it wasn't a lot of money, right? And so it's good to see that some of those issues are being addressed, and we can be more transparent about it. I believe that this is exactly the time to talk about these issues of inequality in sports, in higher education, equity and access. And we have a long way to go. And again, not enough time to get into it fully.
I appreciate that. And now, in an atmosphere when a lot of companies and entities are dismantling their DEI initiatives, I'm proud to say that the Cleveland Cavaliers are actually doubling down and strengthening it. So we have a few minutes for questions. Anything? Please.
Thank you. So we talked a little bit about how NIL is becoming more and more common with high school athletes. I'm just wondering if you see any sort of ethical concerns in that these athletes are being pressured, you know, to focus on sports and brand deals and social media when maybe they should be focusing on education and making friends and just being kids.
Who wants it?
Yeah, that is the main reason why Texas, and I would say Texas and Ohio, along with California and Florida are the kind of the big feeder schools. So 2 permit, 2 don't. But in Texas, that is the huge issue. Also can you imagine gambling going down to the high school ranks? So once money gets involved, how that gets to be an issue. So you're absolutely correct. So what you hear from coaches, school administrators, is how do we protect these young people? So you're spot on.
Yeah, I just want to add to that real quick. It's a great point. It's kind of it's a balancing act, right? So you have high school athletes that have opportunities, and sometimes they're life-changing opportunities for their family. Like, for example, why Ohio's in this situation they're in right now is because an athlete has a $100,000 deal on the table that's life-changing that he basically can't accept. So you balance that against, the risk that, hey, they're not going to be a kid and things are going to get out of control. So it's clearly an issue. But I think on balance that the high school athlete, this is my personal opinion, they have to be put on par with other athletes and in other states, because what happened in the past is those athletes, you wouldn't avoid the issue. They would leave the state. They would go somewhere else, and you'd still have the same issue. So now they don't have to, it puts them on par from a recruiting standpoint. And by the way, it's the few athletes that are going to have this kind of money and this kind of pressure, in my opinion. A very small percentage. We're talking about elite athletes that are going to have this kind of an issue.
The other perspective that I would maybe add, and I agree, it's going to end up being a small subset of these athletes. But if and until states want to start putting laws in place that no one under 18 can earn compensation in any way, shape, or form, I think it's awfully paternalistic or maternalistic, depending on who it is that's doing it, to think that, we need to do this for athletes. Because when you start scratching the surface again, the athletes that are going to be typically receiving these deals are more than likely not white, and they more than likely live below the poverty line.
We have time for one last question. Anyone? Yes, please.
Just a question on where you see the collegiate market going in terms of the haves, the LSUs, the Alabamas, the Ohio States, having even more power over sort of attracting students because they have bigger budgets, bigger media deals, or will that be sort of spread out among all of the universities kind of thing, in a way that the salary cap is implemented in the professional leagues? And then on the player side, is it the Arch Mannings, the Caitlin Clarks that are gobbling up all of this capital, or do you see it sort of spreading out across the entire team, not just the stars?
We have 60 seconds to answer it in the confines of this room, but we can carry it over to lunch. I want to respect Krista's timeline and yours as well. Please.
So I would say very quickly that the idea of capping the compensation only helps Ohio State and LSU, because then at that point, those are the institutions that already have higher level coaching staffs, higher level training facilities, and things like that. If you're an institution that decides we're going to focus on basketball, we may give away football, but we're going to spend more on basketball, now we can compete with Ohio State. So the notion of we needing a cap to maintain a level playing field, or we need to evenly distribute the money across these rosters, again, when you get to the professional ranks, you're going to be earning less than others, regardless of what industry you're in. So if you're not okay with that, you're going to struggle through life. To me, it's a non-issue with these athletes, and in these locker rooms, it isn't an issue when somebody's earning more than you, especially if you know that they have a bigger following, or they're better, or they play a higher profile position, whatever the case might be.
It exacerbates the gap between the haves and the have-nots, and even among the Power Four, and it goes deeper. You're beginning to see even Division III schools being impacted by NIL, because if they develop a great player, they're going to get recruited away. So it's both at the very top, and then it goes deeper.
Thank you, and appreciate everything you've done, Professor Laser, Dean Ray, Jill, Rick up there. Enjoy lunch, enjoy the rest of the program, and stick around if you have questions for us. Take care.
Ari and our esteemed panelists. Lunch is outside. We'll be back at 1 p.m. Also, every table should have room for students. We want this to be a bit of a student mixer with everybody. So make sure that every table has space for students to join as well.
My great pleasure to introduce Don Chisum and Janice Mueller. They're two lifelong friends of mine. They told Krista that they wanted a brief intro, but that's sort of inconsistent with the way I roll. So we'll just see how it goes. So anyone who's of a certain age, and I don't know what it's like these days because we have online research, but for any of us that grew up in an age, Chisum on patents was the Bible. And I've spent countless hours in libraries at law firms and even Fortune 500s, immersing myself in patent law through Don's writings, which was a fabulous experience. And thankfully I was getting paid for it. Don is originally from Phoenix, Arizona. Strangely, but he didn't relocate there. His family was second generation. So his parents were actually born in Phoenix, which is super rare. It's probably a town of 50,000 people back then. Don went to undergrad and law school at Stanford. Then he clerked on the Ninth Circuit in Los Angeles, and then took a job as a professor at the University of Washington, where he taught a variety of topics, including patent law, for 25 years. Left UW and went to Santa Clara. I think started the IP program at Santa Clara. I know when I was looking at law schools, Santa Clara was one of the handful of law schools that had very strong IP program. And that was all obviously thanks to Don. For the last 2 or 3 weeks since this conference has been getting closer, anytime I'm on a Zoom call with prospective clients, and we do a lot of work with law firms, I make sure and drop Don's name. In fact, just yesterday I was on 3 calls. Stella's on my team. She can tell you. I'm like, oh, I got to go. I got to pick up Don Chisum at the airport at 4 o'clock. And people are looking at me like, what are you talking about? So thank you for that boost, Don. I'm sure I closed a lot of deals this week. Janice Mueller, who I also always call Professor Mueller and then get yelled at, so I'm not going to try to call her Janice, but she was my patent law professor in law school. Had such an effect on my career and really kind of took a kid that was kind of a hippie engineer that didn't know what he was going to do with his life and really sort of instilled a love in this practice area and just the vast expanse of things that it could become. She grew up in Ashland, Kentucky, went to undergrad at Virginia Tech University, where I didn't get in, still not mad about that, and then went to William Mitchell Law School in Minneapolis. She is a 2-time federal circuit clerk for both Judge Neese and Judge Rich.
No, 2 years only with Rich.
Okay, my mistake. I knew it was something like that. At one time when I was an in-house lawyer at Kodak, Janice told me where Judge Rich's house was because he's from Rochester, New York. And so I drove by the house and it was no longer a house. But Janice is the author also of a treatise, Mueller on Patents, which is quite a bit different than Don's treatise. Don's is obviously multiple volumes. Janice's is a single volume, and I give it as Christmas gifts to clients because it's a single volume. I have a lot of general counsel clients, a lot of CEO clients, a lot of CFO clients that want to know more about IP, but they're like, it all seems so complicated and endless. And that's the one treatise that you can give somebody that immediately can get up to speed at whatever level you want to get up to speed, the text level or the note level or whatever. Probably says a little bit about me as a client. Most people probably give bottles of wine to their clients or whatever you might give. I give patent law treatises. Anyway, I'm so thrilled that the two of them are here today to speak to us, and I can't wait to hear what you guys have to say. So thank you for coming.
Thank you, Carl. Carl indeed was my law student 25 years ago. And, you know, as every law professor knows, there are just a handful of the students who really stay in your memory. And Carl is definitely one of those. So proud of everything he's accomplished. But I particularly remember that he he took the lead in crusading to start a student law review focused on intellectual property. This was 25 years ago at what was then the John Marshall Law School in Chicago. And today, that law review is in volume 25, and I think that's a pretty wonderful legacy. So thank you, Carl, for that and for many other things. So Don and I were labeled the keynote speakers, and I think that this will not be a conventional keynote, but rather, let's call it a keynote conversation. Our title for this is Chisum and Mueller in Conversation When Spouses Talk Patent Law, Time Capsules, and Mavens. So let me ask if anyone earlier this year, around 4th of July, saw in the news a story from Nebraska, great state of Nebraska, that some folks out there 50 years ago had decided to create and bury a time capsule. And this thing was almost as big as a house. And in this time capsule, which was unearthed this year, this past summer, were all sorts of mementos, artifacts of that time and place. So that would have been 1975 that they're burying this capsule. We had things like teal leisure suits, pet rocks. Anybody remember those? Yes, there's one. And most notably, a 1975 bright yellow Chevy Vega, which in its day was lauded as this, lightweight aluminum-based wonderful car. Unfortunately, a few years later, it turned out to be a real lemon. It had some serious problems with rust and wasn't necessarily a safe vehicle. And Chevrolet pulled it off the market just a couple years later after the time capsule. So anyway, how is this connected to patent law? I am getting there. This time capsule, Don and I have been chatting about starting this summer and moving forward into this program today. We've been chatting about this time capsule as a sort of metaphor, especially with respect to Don's life and work in patent law. Also, 50 years ago, a wet behind the ears young law professor out in Seattle had the audacity to decide he was going to write a treatise on patent law. 50 years ago, all right? And today, 50 years later, somewhere in our house or possibly in the garage, and we live in Kentucky on a little farm with horses and donkeys, but somewhere in our house there is a shrink-wrapped copy of the original Chisum on Patents as it was published almost 50 years ago. And so I'm trying to tie this into my time capsule metaphor, but I think that why people bury things in time capsules, it's a snapshot of who they were and what they cared about and what they believed at in a particular point in time. So, I think in 1975, like I said, you had this upstart young Turk professor who had a lot of thoughts and probably hopes and dreams for our patent system. And now, 50 years later, I'd like to ask Donald Chisum to sort of look back at the Donald Chisum of 1975 and talk to us about, has patent law turned out the way that you thought it would? Would that 1975 author be surprised? Would he be pleased or disappointed about the patent system today?
Well, as your living time capsule just opened up and looking back, then I thought about this and picked out 4 major changes in the US patent system over those last 50 years and started thinking about those four in terms of, are they really improvements in the system as I studied it so diligently back in 1970s. I think, so waking up here in 2025, of course, the first thing that would shock that fellow is the economics. I mean, in the 1970s, we thought it was news if we saw a patent award of $1 million. That was really big stuff. What do we have today? Hundreds of millions of dollars. So the economics have changed, which I think reflects the value of the technology that patents pertain to, which I think has increased way more than even in inflation. So let me do a list of those four. The first two I did not expect to happen. The possibility existed. I did not think they would happen as of 1975. The first was the creation of the Federal Circuit with jurisdiction over appeals from all district court cases as well as from the Patent Office. And the second one was the creation of inter partes in post-grant review. Again, I did not think that would happen. And if I have the chance to talk further, I'm significantly disappointed in how it has worked out. The third one happened, but it took a lot longer than I thought, and that was the switch on the priority system from first inventor to first inventor to file. And the fourth one, unfortunately, is something that did not change. It's very much the same, and that is a doctrine of the ineligibility of patent claims under Section 101. If I have the chance to talk further about the fact it was a gnawing problem back in 1975, and it's a gnawing problem right now in 2025, and it ought to be fixed. I even have a suggestion. So, as I said, I look at these developments, and I have a threshold standard that I apply to any particular change or proposal in the rules, exceptions to the rules, procedures, and standards. And that's in terms of, does it make the system less complex, more efficient, rather than the reverse? And most proposals and changes flunk that test. The test is really based on an old philosophical principle. I think the philosophers refer to it as Occam's razor. Do not multiply entities or procedures beyond necessity. So if you don't need, for example, two standards for a patent specification, written description and enablement, when enablement will do the trick, you should not multiply those entities. Just an example. And I might just mention one other, people might ask me, maybe you would ask me, well, could you give an example?
I was going to mention, for those who don't know, that Don's interest in philosophy and ideas like Occam's razor actually stem from the fact that his undergrad studies were in philosophy. He's a philosophy major.
And who was that?
You.
Oh, yeah, okay.
Okay.
Well, Judge Rich was a major in economics.
Economics, okay. Indeed. But there's
so
more
than
one path forward in patent law, is my point.
Right.
So,
but the example I always give of that, to think about it, one thing that the 2011 America Invents Act did that's totally consistent with that, don't multiply entities, is it abolished as a defense to patent validity the best mode requirement. If you look back at the statute says that a patent specification as filed shall provide a written description of the invention and enable how to make it and use it, and set forth the best mode the inventor contemplated for carrying it out. Now, that's an example of a rule or doctrine that has policy justifications. It seems like a good idea that inventors should disclose their best implementation and not keep it a secret. But in practice, if you look at the case law, the Federal Circuit struggled with all kinds of issues because it was, for example, the best mode subjectively contemplated by the inventor precisely on the day the application was filed. Not a day earlier, not a day later. Questions came up like, what happens if you have multiple inventors and they disagree at what's best? What if the S&E disagrees with the invent? Do you have to update the best mode disclosure? So for very little benefit in terms of better disclosure, we had all these issues that came up in litigation and jeopardized the potential validity. And the AI brilliantly handled that in a way. It left the standard there, but said it has no teeth. It's not grounds for invalidating the claim. It isn't essential for maintaining a priority in a chain of applications.
This is just one of a few areas where I think the spouses disagree on patent law topics. In my academic career, I did a fairly extensive study of patent systems in developing or less developed countries, spent a semester over in India, and those countries see the best mode requirement as a very important part of the bargain. And to just say that because it got complicated here in the US, we should get rid of it, I think that was a mistake.
Yeah. Well, maybe I should talk a little more about number one on the list, which was creation of the Federal Circuit. Why did I not expect that to happen? Well, there was considerable political opposition in powerful groups like the New York Patent Law Association and other organizations to this kind of centralizing of appellate authority in Washington, D.C. So there were arguments and, as I said, political oppositions. I think some would argue that what tipped the scale in favor of creating the Federal Circuit is it was, from an economic point of view, easy for Congress to do, because it turns out they had a courthouse already there in Washington, D.C., and they had 5 Article III judges on the Court of Customs and Patents Appeals, and they had 7 judges on the Court of Claims. So unlike creating a whole new court and appointing new judges, they could just do a conversion of the jurisdiction in the title. But I think creation of the Federal Circuit seemed like a good idea, applying my principle of simplicity. Before that, when I was writing the treatise in the 70s, I had to survey the law of the various circuits. So take, for example, there was case law on many of the circuits on whether a combination of prior art elements was patentable under the obviousness standard. So the Ninth Circuit had one articulation. The Second Circuit had another. It was also known at that time that the various circuits had differing general attitudes about patents. The Eighth Circuit was thought to be notorious in never upholding a patent. And on the other hand, the Fifth Circuit, like in Texas and other parts of the South, they were thought to be very favorably disposed for patents. So that kind of conflict between the circuits led to forum shopping in a way. Lawyers went to great effort to get their case in one or the other. But it also was the background actually for the infamous or notorious or important Supreme Court precedent in Graham v. Deere, because actually one of the patents at issue there was on a plow, and the Eighth Circuit had invalidated it, applying one standard, and the Fifth Circuit had affirmed its validity. So it does seem like a good idea, because now we'll have a single appellate court and we will get a clear, consistent opinions providing guidance on these important
And
points.
especially for a treatise writer in 1975 who used to have to track, 10 or 11 different regional circuits on their views on all these various patent law topics. It must have been a godsend to you in 1982 that we thinned it down to a single court of appeals.
Well, yes and no. I mean, from a treatise point of view, the more confusion in a way, the better. The more people need a treatise to figure out that. But for the health of the system, simpler is better. And especially in the early days of the Federal Circuit, they did issue a lot of clarifying opinions. Now, it's kind of interesting. The legislative history of the Federal Courts Act assumed that the workload of the Federal Circuit judges would be lighter. The caseload would be lighter than that of the judges in the other circuits. And that was thought to be justifiable because the Federal Circuit judges would be deciding very important issues that had nationwide applicability. So they presumably could spend more time and write more careful opinions. And indeed, they were authorized to hear cases in panels of 5 judges, which, to my knowledge, they have almost never done. And they are also allowed to hear cases in bank. If they had lighter caseloads, they could do that more. Now, it did not work out that way. Their caseload, because of the growth of the patent system in a number of ways. So another problem that arose, of course, is that opinions are written by panels of 3 judges. And commentators began to comment that certain panel opinions were inconsistent with other panel opinions. And indeed, you have to fairly say that the court developed some schisms, for want of a better term. I mean, there was a question of the role of dictionaries, for example, in interpreting patent claims. Some said it was always presumptively correct, and the scope of a prosecution history estoppel. In time, the court worked those out. In some cases, it was by the Supreme Court. But I think it's fair to say the court has the biggest problem I think today with the court is a topic I'll get back to, which is inter partes review and the sheer volume of appeals that are pressed on the court. Personally, I think they are interfering with the court's ability to address the full range of patent law issues in a careful, thoughtful way.
I will note, just because I track and follow the Federal Circuit precedential cases just like Dawn, there does seem to have been a slight decrease in the last few years in the overall numbers. I don't know, Dennis, if you're seeing this, but 4 or 5 years ago, we were well over 100 precedential opinions a year, and in the last 3, 4, 5 years, it seems like it's gone back to something closer to 80. But even that number, I mean, think about it. In patent opinions, over 1 every week of the year, and it's a lot. It's a lot to keep track of and to keep on top of. And even in one very particular area, for example, Section 101, patent eligibility, that we're going to talk more about. In the last 10 years, we've counted up
100.
100.
There's 100 precedential opinions dealing with
101 eligibility.
Yeah, since Alice in 2014, there is 100 precedential opinions on whether a claim as directed to an abstract idea and therefore is ineligible under the famous Mayo-Alice test. And so what parties end up doing is not only citing potentially different nuances of language in different precedents, but also just very factual similarities in terms of the subject matter of the patent. So
should we leap into 101 now? I know that's out of order.
Do we have to leap into 101?
Well, because you have a brilliant proposal.
Well, I wouldn't necessarily call it brilliant, but so what should we do about 101? Okay. Well, as I mentioned before, going back to 1975, we had a 101 issue in particular, I've always identified the 1972 Benson decision by the Supreme Court, which held that a mathematical algorithm was unpatentable as the source of all of the problems thereafter. It was a badly reasoned opinion, and it misused old Supreme Court case law. And
Justice Douglas,
it
right?
was written by Justice
was
Douglas.
Not a fan of
Not
patents.
a fan of patents. It hoists the idea that a new technology, such as computers, was not patent eligible subject matter unless it was authorized by Congress. Well, think about that. What is the patent system all about and always has been? New technology, right? It's the same. Congress has to anticipate. Actually, that idea, I think, got trimmed back by the Supreme Court in the subsequent Ceccarati decision. But the idea is still with us, this notion that a claim to a process or a product that otherwise meets the definitions of patentable subject matter in Section 101, which you all know is manufacture, machine, composition of matter, or process, that it is ineligible, even though the subject matter meets those definitions, under a judicially created exception, because they're deemed to be to an abstract idea or a natural law. I thought in law school I was told that judges didn't create exceptions to statutes. They rule on their constitutionality, but they don't create exceptions. Again, if we move forward, we have a new set of cases to struggle with, like Mayo and Alice, but I think the flaw is the same. And by the way, having this doctrine violates, I think, my simplicity standard, because generally, if you read and think about the cases that are held ineligible as to an abstract idea, almost every it's because it's conventional. It's like cases that say, well, this is just taking an old method and applying it on a computer. Well, we have a doctrine, another doctrine of patent law.
It's called?
And what would that be?
Non-obviousness.
How about non-obviousness? Something actually the Supreme Court addressed in a forgotten case. There was a case involving applying software dealing with banking on a computer. The Supreme Court said that was obvious. They didn't look at Section 101 subject matter.
Can I just interject a little note about?
Sure.
I had the great privilege of clerking for Judge Giles Rich of the Federal Circuit, and he had his own metaphor, not the time capsule, but the three doors to patentability. And I know Carl's smiling over there because we used to talk about this in patent law. The first door being Section 101, none of us at the time really thought of it as this incredibly complex filter. The words used in the statute, the four categories Don just named, were very broad and had the word any in front of them. Judge Rich talks about it in his the foundational Berge case, and he says, we really, just to even approach that first door, we look at have they themselves made an invention? Are they an inventor as opposed to just a copyist or a deriver? Because without that, you cannot even approach the first door. But I think he saw door number one as quite broad. And he also cautioned us in Berge that you don't analyze inventions under that first door, Section 101, for novelty and non-obviousness. Those are separate doors. So it seems to me that the law as it has developed has unfortunately combined and mixed together all those concepts, which used to be quite separate.
Right. Well, I know there are proposals that have been over the years for a legislative fix, an amendment to the statute. I have not been a big fan of legislative fixes because usually various interest groups get involved and you end up with exceptions or ambiguous wording. It is not the solution I think that the historic patent system needs. So I strongly would hope that we could figure out a way to overrule, cut out the cancer that started in the patent system with that 1972 Benson case. So I think the way to do it, to get that achieved, is as follows. Now, many, for example, patent owners have attempted petitions for certiorari to try to review Federal Circuit cases on Section 101, and they've been uniformly denied. But I think that the court would respond differently, perhaps, if it received a petition from the government. And it's sort of the way it was done in reverse back in the 70s. The way it worked in the 70s is the patent office was taking a not patentable approach to software and living subject matter and the like. And that applicant would appeal to the CCPA then, the Court of Customs and Patents Appeals, and then well-informed judges like Giles Rich would write opinions
In Ray Berge,
knocking over
right.
the patent office position. And then the government attorneys, like from the Department of Justice Antitrust Division, and would go to the Solicitor General of the United States, let's go for certiorari. And that's exactly how Benson happened. That's how the Fleck case happened. So I think that what we need is a test case. It'd be cool if, for example, our current director, who keeps saying he's in favor of broad subject matter eligibility, could figure out a way that we could get such a test case. Maybe a PGR, post-grant review, involving, well, I think a good candidate would be some of these applications dealing, or patents dealing with medical diagnoses. What's good about those, a lot of times, novelty and unobviousness is clear. So this is one of the rare instances where you can really say 101 is this obstacle, and it makes no sense in this context. So if we could get that set up, and then, as I said, as soon as the Federal Circuit said, oh darn, this is not patentable subject matter, and then the government would petition the Supreme Court for review. Now, the way I know this makes the Federal Circuit seem like the fault person, because they can say, well, we're just applying, Mayo and Alice, which they often, it's exactly what they are doing. The fault in this area is not the Federal Circuit. It is the Supreme Court. But in terms of tactics, I think, if you frame the petition as one saying, did the Federal Circuit err by reading the Supreme Court cases as creating an exception to the clear wording of the patent statutes in Section 101? When you frame it that way, the answer is clear, right? No, courts do not interpret statutes to create exceptions.
I know we want to spend plenty of time on IPR and PGR. Did you want to say anything more about the switch to, first inventor to file?
First inventor to file. See, that's the one where I thought that was going to happen sooner rather than later, back in the 1970s. And I was surprised it didn't happen until, a long time thereafter. So it actually affected how I organized the treatise. For example, I did not write a major section on interference procedure, which is a whole complex body of law unto itself. So I said, well, you're likely going to be switching to a first file system. So, but as the years dragged on, I said, well, I better add that. And I became quite interested. It's really a very interesting area of the law. And in case you have some lingering interest, I think you'll find good reads in the Federal Circuit's opinions, and what may be one of the last great interferences, that involving the CRISPR gene editing patents. It's just great old interference stuff. You know, you've got
Just this year.
dueling conceptions and it's cool stuff.
Yeah. So.
But that's the system that we walked away from. So in any case, but again, I think that there was a lot to be said in favor of the first invent system in terms of our constitutional history. But if you apply my simplicity notion, the Occam's razor, turns out for a huge percentage of the time, the first filer won over an alleged earlier inventor, conceiver, or reducer to praise. Some of the most famous, other famous historic interferences were ultimately decided on that basis. A huge interference was over the polypropylene. It involved 4 or 5 companies from Italy, from Germany, from the United States, but eventually, I think it was Phillips Petroleum won based on how they were really actually the first to file, interpreting an application they had filed as providing an adequate written description of the interference count.
So it would seem that the U.S. going first to file and putting us in line with the rest of the world was a no-brainer. Why did it take so long?
Well, here's one theory. Back in was it the 90s? Something. The United States wanted other countries to change their restrictive grace periods.
The pre-filing 1 year.
Yeah, they had a first to file system. So there was sort of an offer of a deal, basically. Said, we, the United States, will give up our cherished first to invent system, which has a grace period and will continue to have a grace period as it does, if you will change your very minimal grace period to one similar to ours. So there was discussion back and off, and the deal never happened. So I think that may have delayed for a decade or more, the switch.
Do we want to turn now to post-issuance review in the Patent Office?
Oh, why not? This is dynamite. Now, I have some very specific ideas. Well, again, this is something I did not expect to happen. There was a presidential commission in 1966 that surveyed the patent system and made certain recommendations. I had a hard time finding an actual copy of it, but I've seen summaries of it. And it had things like a 20-year from filing patent term, but it also had a recommendation for post-grant protests that would be similar to the systems of opposition and cancellation that existed in the patent system of other countries. And again, it was opposed. There was strong opposition on the ground that it would, weaken the value of patents and enable well-heeled challengers to tie the patent up in the patent office proceedings. Sound familiar?
Imagine that.
I was a little surprised that, in fact, along comes the 2011 America Invents Act, and we get this system of inter-parties review and post-grant review. So the purpose, as I understand it, is to provide an avenue for patentability disputes that is faster and cheaper than district court litigation.
That sounds like it's in line with your simplification
Yes.
policy.
And it improved on the deficiencies that were thought to be in the previous systems of ex parte and inter partes reexamination. Now, again, back to my standard for assessing changes, which I try to think of as nonpartisan and simply, is it making the system more efficient and not unnecessarily complex? One of the reasons to simplify a system, by the way, I need to make this point, is human error and mistake. I don't know how many cases I read from the Federal Circuit in which underlying it all, somebody made a mistake, didn't write the claim the right way, didn't make the argument. And when you have an extremely complex system, it lends itself to that kind of mistake. And that's separate and apart from what should be the most basic issues in any patent situation, which is this, as disclosed, a patentable invention? What's its scope? Is it infringed, in other words? Who owns it, and what is it a remedy for infringement? But so many additional requirements and procedures get layered over it. It's not surprising that people make mistakes, like litigators in their briefs. They always flinch a little bit, for example, when somebody makes a really good argument on appeal, but it's in a footnote and not elaborated, because appellate briefs are subject to strict page limits. And they will say, arguments and footnotes don't preserve the issue. I'm a guy who's written thousands of footnotes, and so I'm offended by the idea that a footnote does not carry force. But okay, there you have it. So this seems like it could be a simplifying the system if it worked as it was sort of broadly conceived. But in fact, what has happened is that inter partes review petitions often just are one more theater in the war of litigation, not replacing it. As I think I mentioned before, I'm also concerned that this is eating up so much of the time and attention of the Federal Circuit when they could be spending it on a broader range of issues. Because IPRs involve a lot of complex appeals from them, procedural and jurisdictional questions. But I think that the limitations that are in the statute are a big part of the problem and hamper IPR from achieving its intended purpose. So I have a little list of these limitations that, like in the Mikado, a list of limitations and requirements that we could do without, that would never be missed. And many of these would involve amending the statute.
For those who are not the opera buff that Don is, the Mikado is an opera, and they talk about a little list. So
they know that. Anyway.
For the record.
Yeah, it's an operetta, English. Operetta. Anyway. So many of these ideas I have are in the statute. So you would be talking about amending the statute. But there are proposals abreast now to amend the statute. And the ones I've looked at just briefly, I have a problem with. I don't think they attack other aspects that would make IPR better serve its intended purpose, which is to provide a resolution of a whole patentability issue. So I'm against any amendments that don't, use Occam's razor and simplify, and in some cases maybe broaden.
How about the burden of proof?
That's perfect. Yes, so the perfect example of having two standards, what we could do with one. So the statute for IPR says that the petitioner for IPR shall bear the burden of proving a proposition of unpatentability by a preponderance of the evidence. You all know that when attacking the validity of an issued patent in a district court, the burden is clear and convincing evidence. And that's been upheld by the Supreme Court on reasoning that's quite credible. It's in part Congress could deem it important to make investments in issued patents more secure. So there's a justification for having a higher burden of proof. Now, I'm somewhat skeptical of how big a difference it makes and how, but nevertheless, it has some consequences. But again, why have two standards when we could have one? And why was it kept in there in the first place? I think there was a little bit of just, it was in the original re-examination statute going way back to like 1980, or it was interpreted that way. And the theory, I think, then was re-examination was really intended to be a quite limited, almost like continuation of the original examination. And indeed, that was kind of central to the rationale of the Supreme Court in upholding the constitutionality of inter partes review. The Oil States case, they said, the Supreme Court majority said that they sort of assumed nobody argued that you had a right to an Article III district court to find facts with regard to the government decision to issue a patent, that could be done by an agency. And inter partes review, like the previous re-examination, is kind of allowing the government to redo that and make up for a mistake. Well, I have problems with that rationale because the way inter partes review has worked out, it's very much not a continuation of the patent office examination of the application. For one thing, we've made it very, very clear, Supreme Court has made it clear, that the issues in an IPR are those that the petitioner frames. So it's not telling the office they can find any new thing. And by having a different standard, you limit the collateral estoppel effect of a board decision. There was a recent 2025 case, the Croy case. Situation was something like this. In an IPR, let's say the board finds a claim unpatentable after ruling in favor of a petitioner and against a patent owner, and it's based on an interpretation of the claims and on a finding about what the prior art reference disclosed. So that is what the board has found. And let's assume the Federal Circuit affirms. But then in the district court, the patent owner asserts another claim in the same patent that raises the same claim construction issue. Prior art disclosure is an issue, but the claim is a little bit different. Shouldn't that be, under most principles, collateral estoppel? We have a strong policy in the law. Once something is settled, it's settled between the parties. But the Federal Circuit held in this Croy case, I think probably correctly, well, no, there's an exception to collateral estoppel when the governing legal standard is different. And in this case, the governing standard is different because the burden of proof was so much lower in inter partes review and it's higher. So you see how we would, if we eliminated two standards, we simplify in that particular respect. So.
How about the limitation of IPRs to patents and printed publications?
That's a good one.
Is that something that we could or should change?
Okay, so you're all familiar with the statute that says that a petitioner can request IPR to cancel a claim only on a ground that could be raised under Section 102 or 103, and only on the basis of prior art consisting of patents or printed publications. So what does that exclude as a ground? Well, it excludes anything other than 102 or 103, which are lack of novelty over the prior art, obviousness in view of the prior art. It excludes entirely Section 112 issues. Now that, I see no justification whatsoever. What is the justification for saying the board cannot consider Section 112 issues?
Examiners deal with that all the time.
What?
Examiners deal with 112 all the time, so why?
Well, of course, enablement and written description are something examiners consider all the time. But the board in an IPR
is not supposed to.
Has to consider 112 issues as well. Not as the ground, but for example, they often have to determine what the date of the challenged patent is. And that may depend on whether a priority application it claims the benefit of complies with 112. So clearly the board is competent to decide Section 112 issues. And they have to do the same thing even for new claims or amended claims. So I really cannot see the justification for that.
And how about the 12-month time bar?
Well, I haven't finished with publications yet.
I know, but our time is getting a little short. And I wanted to ask for questions too.
Okay. Well, but anyway, it excludes like public use and on sale bars, and I don't think that's justified either. So what else am I supposed to?
The time bar.
The time bar.
1 year time bar.
Yeah. You know, the statute says that someone needs to file a petition for inter-parties review within 1 year of being served with a complaint for infringement of the patent. Now, why have that bar? What's the purpose of that? I think the purpose was roughly this, that if somebody is sued for infringement and they're going to challenge the validity of the patent, they should make a choice early in the litigation. Are they going to go over to the PTO in an IPR, or are they going to leave it to be decided in the district court? Well, I just don't think you necessarily need such a rigid rule. Cases came up. There was a 2020 case involving Facebook, I believe, in which a patent owner sued alleging infringement of the patent. The patent had 100 claims, let's say. Didn't say which claim was alleged to have been infringed, and let's assume the claims differed significantly in scope. So somehow or another, the accused infringer doesn't manage to force the district court to require the patent owner to state precisely what claims he's going to assert. But so they guess and file an inter-parties review petition just short of the 1 year. Sure enough, shortly thereafter, the patent owner amends the complaint and charges specifically other claims, ones not challenged in the IPR. Well, the 1 year time bar seems to preclude that. Now, what they tried to do in the Facebook case was to file a new IPR that was barred and then use the joinder provisions that's in the statute. And the Federal Circuit held, probably correctly, that won't work. That's only when in some other party. You cannot file a second IPR just to raise a new. Well, now, in these days of IPR, as I guess we all know, the current director is taking the position that the director has virtually unfettered discretion to decline to initiate IPRs. I'm not sure that that's wrong. I do think there should be standards governing that, but I think that is the way to handle the late assertion of IPR. In other words, it would be a factor in exercising the stage of the litigation. But you no longer need, I think, in light of that, a rigid, 1 year rule. But anyway, I think there are, in other words, one should look at IPR, assuming you were going to retain it, personally, I would not oppose repealing it. But we had a patent system that worked just fine up till 1975 and until 2012, in which we did not have post-grant. We have competent district court judges. We should sometimes look at some of the procedures so that patents that are clearly, invalid can be more summarily disposed of on summary judgment and the like. We need to make, if we're going to retain the system, we need to make it work more efficiently and more clearly and less error prone.
Well, we have just a few minutes left. If there are questions from the audience. Okay, we saw you, and then we'll start over here. Okay, we'll start.
I have one question regarding the polypropylene patent. And
interference.
This Nata was the inventor and got the Nobel Prize and got the worldwide patent, but US. He was rejected for US patent. I want to know how long that patent was pending after the application.
So is the question, how long does the patent that Phillips got last?
Not Philips. I mean that Nata is the Italian company, who after filing, how long it took to get the rejection?
What was the total time of pendency?
Oh, what was the total time? I'd have to go, I know a good book where I can find a description of that case. The applications were for the various conflicting applications were filed in the early 1950s. And I don't think the interference was decided well into the 70s. So it was a long time, which was always one of the huge issues with regard to interferences, of course.
Question over here.
Get my exercise today.
Oh, and thank both of you for being here. My question is, as both of you are discussing, the Supreme Court doesn't have a very good reputation among us patent folks. But what's so striking is most of these Supreme Court cases, Alice, Mayo, KSR, going back through history, are unanimous and come from judges across the spectrum on many other issues. And so do you have any inside opinion on what is it about being a Supreme Court justice or being someone who's appointed to the Supreme Court that you struggle with patent law in the ways that we like to complain about?
You don't have this. I think I understand your question is that you don't have the same political sense that we might see, conservative, liberal, et cetera. Those don't apply so much to patents.
Oh,
and
yeah. The justices are kind of interesting is how they divide on patent cases. I think they enjoy that, is my opinion. That is to say, even some of the judges that you would identify, justices you identify as deeply conservative and some deeply liberal, will team up on a patent issue. And I think that's why sometimes they are induced to grant cert. I really would, and I think that that may or may not come into play if we can get them to take a 101 issue, which I truly wish they would do. Because all those prior opinions were written by justices no longer on the court.
All right, I think our time is up. Thank you so much. And we'll hear more from the next panel on some of these same topics.
Did we just witness what dinner time is like at your house?
Yeah, scary. I know.
My takeaway was that Alice is a yellow Vega. I don't know if anyone else got that opinion.
A yellow Vega. It's rusty and didn't work well.
All right, folks, let's sit back down and we'll get started. So I'm looking forward to this fireside style chat. Should be really fun with judges Linn and O'Malley, and then we'll open it up for our AllStars to come back up. Brief intro to our moderator, Steve Auvel. Steve's the managing partner of the Cleveland office of Squire, and thank you again to Squire for helping to sponsor, in addition to our other sponsors. He has practiced IP for over 30 years and has been active in the Cleveland community, including leading CIPLA and the Kathleen O'Malley Inn of Court, and serving on the board for various local foundations, including the Playhouse Square Foundation, the City Hub of Cleveland, and Team NEO. Judge Kathleen O'Malley founded Kathleen O'Malley LLC, where she focuses her practice on litigation consulting involving a broad range of subject matter, including alternative dispute resolution and intellectual property policy work. Prior to starting her own firm, she was of counsel at Sullivan and Cromwell and Irell after retiring as a federal judge for more than 27 years, including most recently on the U.S. Court of Appeals for the Federal Circuit, and previously as a judge on the U.S. District Court for the Northern District of Ohio since 1994. She's the first former district judge to be on the Federal Circuit. And after her judicial service, she also served as First Assistant and Chief of Staff to our beloved former Dean and then Ohio Attorney General Lee Fisher, supervising the office's 1,000 employees. And before that, as Chief Counsel to the Attorney General. After her clerkship with the Honorable Nathaniel R. Jones, she began her legal career litigating at large firms in Ohio. She's also won numerous awards and honors, most of which are for the development of IP law. Judge Richard Linn was appointed by President Clinton in 1999, and prior to his appointment, he was a partner and practice group leader at Foley and Lardner from 1997 to 1999, and head of the intellectual property department at Marks and Moraes from 1977 to 1997. He served as a patent examiner prior to that from 1965 to 1968. He was a member of the founding board of governors of the Virginia Patent Bar Section, served as chairman in 1975. In 2009, he received the New York IPLA Leadership Award and the NGIPLA Jefferson Medal. In 2010, he was awarded the Outstanding Public Service Award by the IPLA. In 2011, he was awarded the inaugural Mark Banner Award by the ABA and the Sherman Christensen Award by the American Inn of Court. He was also awarded the Outstanding IP Achievement Award by the Philadelphia IPA, and in 2013, the Distinguished Judicial Service Award from the Intellectual Property Association of Chicago, as well as many other fantastic awards. And I will say that just a brief note off the intro is that he's been critical for the development of various inns of court around the country as well, continuing to push for that. He served as an adjunct professor and professorial lecturer at the George Washington University Law School, which is my alma mater, from 2001 to 2003, and served over a decade on the school's IP advisory board. He's a past president of the Giles Sutherland Rich American Inn of Court, a member of the Richard Linn American Inn of Court, and a visiting member of the Honorable William C. Cotter American Inn of Court, an honorary lifetime member of the Benjamin Franklin American Inn of Court. He received his bachelor's Bachelor of Engineering, right? From Rensselaer Polytechnic Institute in 1965, and a JD from Georgetown in 1967. He assumed senior status on the Federal Circuit in 2012 after his illustrious career on the circuit. So I turn it over to Stephen to moderate this conversation.
Hello, everyone. I feel very small right now next to the two of you. So let me just begin by saying last night we started a conversation. We were at a joint meeting of CIPLA, our local bar association, IP Bar Association, and the Kathleen M. O'Malley Inn of Court, named in honor of the person sitting next to me. We had an interesting discussion talking about the roles of inn and courts, bar associations,
And we started to get into some other areas about the court. And I'd like to pick up kind of where we left off yesterday. And just to kind of, as a reminder, you just heard that these two judges have served for many years. Judge O'Malley was the very first Federal Circuit judge, and only two in its history, that served as a district court judge beforehand. And so she brought really unique experience to the bench. And you served together on the Federal Circuit for about 12 years, I think, or no, 14 years, roughly. And so you were colleagues. So I want to just kind of set the table a little bit by asking Judge O'Malley if you could just, share your, different experiences being first a district court judge with a broad swath of, general jurisdiction cases, and then moving on to the appellate court where smaller a number of subject matters that you dealt with appeals, but in a different role as a reviewing court judge. Can you share that experience with us?
Sure. They're very, very different jobs. People always ask me which one I liked best. And if I had to really fall off the fence, it would be the district court, just because it was different every single day, and I interacted with so many lawyers, and I loved it. And you also didn't have to get anyone else to agree with you, other than the Court of Appeals, of course. So that's there was a joke that my husband used to tell when I took the bench in DC. He said, "Remember, Kate, you now need another vote all the time." And he said, "And I'm not necessarily going to give it to you." But so there were big differences. I liked being able to delve into cases a little bit more at the Federal Circuit. I didn't have that luxury as much at the district court. I liked the interaction with the other judges where you would disagree on topics and you would really talk it through and try to come up with a resolution. It didn't always work. That's why there were dissents. Or sometimes just per curiams, which people always wonder about that, but that often means that the answer was agreed upon, but not the way to get there. So I liked both experiences a lot. I loved working with Judge Linn. We seemed to always agree, which was handy, because there were several others on that court that I did not always agree with. But for me, I felt like I had fabulous opportunities at every step of the way. I loved working for Lee Fisher, the former leader of this school. And I thought that was about the best job you could ever have. And then all of a sudden I was on the district bench and said, "Oh no, this is the best job." And then the Court of Appeals, I'm like, well, this is pretty close too. So they were all great experiences. The one thing that did surprise me about the Federal Circuit is that everybody thinks of it as the patent court. And it's true that there are a lot of patent cases, but the jurisdiction is much broader than that. I used to joke that I would get all excited because I'd get a tax case. So it was different. And people would say, "You like that?" I'd say, "Yes, I do." And I like the fact that it's not patent law, because you don't want to only be in a rut. And as I understand it, when the court was formed, one of the compromises was that in order to make sure that you don't get just specialized judges on the court, and the judges retain sort of more general jurist approaches to the law, that's why they kept these other areas of the law. I loved the veterans cases. They were complicated and sad. The vaccine cases, the dumping cases, now they got the tariff case. Who would have thunk? So, people said, people asked me, how did the Federal Circuit get that? Aren't they the patent court? Well, the answer is not really. There's a lot of other areas of jurisdiction that the court has.
Judge Linn joined the court in 1999. It's the law's changed quite a bit in the federal circuit since you joined the court. Maybe share with us the experience that you've had in the court, how it's changed over time to here we are sitting in the end of 2025.
Yes, and let me first say how thankful I am to be here. Thank you for inviting me, and I'm enjoying my visit to Cleveland. I hope this won't be my last visit. But to answer your question, when I started on the court, things were really quite different. There was no AIA, so we had no appeals from the PTAB. There was no PTAB. And yes, we had a very robust docket of patent cases coming up from the district court, but we had a host of other cases in the other areas of our jurisdiction. There were, fantastic takings cases, Fifth Amendment takings cases. We have jurisdiction over all money damage claims against the federal government. And, we had all kinds of cases about some property owner in Florida that his beachfront property was destroyed by the Army Corps of Engineers, and that was a taking without just compensation. Okay, interesting case. Then there was the Yucca Mountain nuclear waste site disposal contract dispute, where the government decided that, well, nuclear waste should be stored someplace, so the government will build a storage facility in the heart of the Yucca Mountains and require all nuclear plants to send their nuclear waste to that facility. And to pay for it, the nuclear plants would be charged, a fee. And over the years, the nuclear plants did pay those fees. And in due course, the government came to its senses and said, this is not a good idea to build something like this in the center of the United States and to have nuclear waste being transported on trains across the country. So they reneged on the deal. And the first question was, well, did the government enter into contracts with the nuclear facilities? And if so, was that a breach of contract for which the government owes money damages? And there were just a host of cases, one case after another, where the nuclear facilities were trying to recoup the costs of storing their nuclear waste while they were waiting for the government to do this. And that's just one example of just a lot of different cases in a lot of different areas that I thought were fascinating. And I thoroughly enjoyed that. I mean, as you heard from my background, I'm a patent guy. I'm just like you. I always enjoyed patent law, intellectual property law in the broadest sense, and I look forward to hearing the patent cases, but I really enjoyed learning about all the other areas of the court's work. Over time, that has changed dramatically. First of all, most of these takings cases have all been sorted out, and somehow we don't get those kinds of cases anymore. We used to get lots of government contract cases with a breach of contract on building a new aircraft carrier. We don't get those cases anymore. I don't know why, but we don't. And taking the place of all of those cases, enter stage right, the PTAB, and all of the AIA appeals. And right now, the court's docket is well over 50–60% patent cases. And the other cases are relatively insignificant. I mean, they're significant for the parties, don't get me wrong, but in terms of our overall docket, patents really dominate the landscape. And the PTAB cases are about half of the appeals. And they are validity cases. It's, in effect, we have returned to our roots as the CCPA, which was just an appellate body from the Patent Office. And you know, those cases are important. The issues are difficult, and they're and I enjoy them, but it's a different mix of cases. I really enjoyed the appeals from the district court much better. They're, you know, full boatload of issues, and it just makes for a more interesting, challenging scenario. So in that sense, the court's docket has shifted dramatically.
I just wanted to add one thing about the PTAB cases. There was a comment from Professor Chisum about their interfering somewhat with the Federal Circuit's ability to develop patent law, and that's really true for not just because of the volume, but because the standards are so strange. I mean, it's an APA standard of review. The burden of proof is so much less. The Federal Circuit almost has to rubber stamp the vast majority of those cases. So they're not able to dig into deep patent law issues like they could with the district court. And just watching it come was actually one of the reasons that I decided maybe it was time for me to leave the bench. I mean, there were other reasons too, but I didn't think that I was going to end up as a patent examiner at the end of the day. And when I went to the Federal Circuit, it was to do patent law and to continue to do other areas of law. So when I saw that trend, it worried me. And I still think it's worrisome because I think you're wasting a lot of talent at the Federal Circuit because of the standards of review and the narrowness of the review. And that a lot of the good issues that were going to come out of the AIA, which I kept finding myself on the losing end of, which had to do with the statute of limitations, the one-year time bar, and whether or not there was, for instance, things like complete discretion in the director. Those were all things that I thought were interesting interpretations of the statute that could be had. The Supreme Court basically said, no, the statute really doesn't mean what it says. It's really just all about invalidating patents. And we're going to allow the director to do anything that gets us further down the road toward invalidating patents. And that's the way I interpret many of the Supreme Court decisions under the AIA.
Maybe I know the answer to the question, where you just answered it in a way that, but one observation is it used to be for a number of years in the 90s and 2000s and even 2010s, it seemed like there were more en banc panel or en banc decisions from the Federal Circuit, and that seems to have dropped off pretty significantly. First of all, am I right about that? And number one, and number two, why is that?
Well, I think you are right. It has dropped off, but I don't know that there's any particular reason underlying that. If a case comes up and the issue is important enough, and there's either a conflict or some reason why some established precedent needs to be reviewed, we'll review it. I don't know that there's anything behind the fact that we just haven't had that many en banc cases.
I can speak a little more freely because I'm not on the court anymore, but right before I left, there were several very divisive cases in which the judges were in radical disagreement on a variety of issues. And we came out with a variety of decisions that were 7-5, 6-6, even in one occasion, and it wreaks havoc on the collegiality of the court. And so I don't know that I ever heard a conversation to this effect, but I think there was a conscious decision to avoid voting for more en bancs, because very often when things went en banc, just like when things are taken by the Supreme Court, things get messed up more, or at least more confused. So I think there has been a conscious decision to avoid en banc unless the issues are so important that the court feels it can't avoid it.
Yeah, I would just disagree slightly with that because I really don't think there is any, conscious concern about taking cases en banc. Yes, there were decisions where there were vigorous debates, but that's the nature of the game, and that's fine. I think judges are used to that. I just don't think for one reason or another, I just don't think there have been issues that have come before us that the court felt warranted en banc review.
Well, the Supreme Court has also, I'll say the Supreme Court has shied away from taking patent cases in the last number of years after being involved heavily over, a 15-year period of time. Maybe you could speculate on why that is, and would you like to be like that to be different? We heard earlier from Professor Chisum that he would like to see the one-on-one issue taken up by the Supreme Court, and had a creative idea about how that would might come about to address, the one-on-one issue around the standard. What are your thoughts on that subject?
Well, I was on a panel not long ago, and the question was posed, what issue do you think the Supreme Court should take? And my answer was none. You be careful what you wish for, because the Supreme Court just, they're not in familiar territory with patent cases. And, the 101 decision is just an abomination, and it has caused tremendous problems. And I'm, both Judge O'Malley and I are directly familiar with that, because the original Alice case, before it started with a 3-judge panel, and Judge O'Malley and I were on that panel along with Judge Prost. And I wrote the opinion, Judge Prost dissented. I wrote the opinion basically saying that the invention in question was patent eligible. And basically I went through a little bit of history. This problem started with the idea of, let's look to see if the claim directed to an abstract idea. And that sort of came from Bilski, an earlier decision, again from the Supreme Court. And the opinion that I wrote, it went through the history of the statutes. It talked about 101, 102, 112 doing the heavy lifting, and 101 being a gatekeeper. The strong, broad, sweeping language of 101, and that we shouldn't inject judicial constraints on that broad statute. And I think the holding was that, yes, the district court should look to see whether the claims are directed to something that is just overly broad and preempts a wide swath of technology, or is directed to nothing but an abstract idea. But when in doubt, unless it is manifestly evident, and that's what the holding was, unless it's manifestly evident that the claim is nothing more than an abstract idea or a law of nature or something of that sort, then pass it along and let 101, 102, 103, and 112 do the heavy lifting. And I guess the fact that there was a dissent prompted the en banc Federal Circuit to take up the case, and there was a vigorous split of opinions on that case, and that sort of caught the attention of the Supreme Court, and now we're in the morass that we're in. And I think Professor Chisum said there were 100 101 cases from the Federal Circuit. I think that's about right. And the odd thing is, what other area of law results in a decision not applying a broad principle to the facts at hand, but saying, well, let's look at the facts in hand and let's compare. We've got 100 cases. There are 65 of them that say it's ineligible. There are 45 that say it's not eligible. or it is eligible. So are your facts closer to these, or are your facts closer to those? And that's how the case is decided. That's, to me, that's absurd. So the law is that this bunch of cases is ineligible, this bunch of cases is eligible. It's just a very odd situation. Now, we had a petition not long ago in a case called American Axle. And it was a mechanical case with some sort of a torque tube in an automobile. And I don't know the technical detail, but it was fairly simple mechanical technology. And, or there was a vigorous army of amicus briefs petitioning for cert. And here's a case, finally, we've got a case that the Supreme Court might take. The technology is simple, they like that, and they know that the 101 is just hotly debated and it's time to take another look, okay. And you've got new justices on the Supreme Court, justices who are, strict textualists, who don't like the idea of reading limitations into a broad statute. So maybe this is the one. And lots of folks predicted that would be the case they would take. And I read every single one of the amicus briefs in that case, and I read all of the principal briefs. And the one thing that I came away with was that I did not find in a single brief an alternative test to the two-part Alice Mayo test. And I said to myself, they're not going to take this because nobody has suggested to them a better way to do it. And they're going to leave this mischief alone. And that's exactly what happened. So, Don Chisum, I hope you're right. I hope they do take the right case, but my concern is that they won't do any better. I would like to see some sort of a legislative solution. The Federal Circuit can't really do anything. But the problem with a legislative solution is that there are too many different groups that are lobbying for different positions. So again, nobody has come up with a better test. We need to find a better test. Even if it's a compromise, then not everybody wins because we'll all be better off.
I just want to, that is a bit of a segue. I just wanted to respond a little bit to something that Professor Chisum said about the current legislative proposals being imperfect. I think that's the problem with legislation. It has to be imperfect because you have to get buy-in from so many different areas. But I think it's better than nothing. And I fear that we're going to let the perfect be the enemy of the good, and we're going to say, well, then let the Supreme Court fix it. And I agree with Judge Linn, the last thing that it's going to do is fix anything. I think with the Supreme Court, it's a broader philosophy. I don't think they're bad at patent law. I don't think they care about patent law. I think what they believe is that from the very beginning, there never should have been patents. There shouldn't be intellectual property rights. This goes all the way back to the founding fathers. The debate between is antitrust worse or is not having intellectual property rights worse. And I think the majority of the justices on the Supreme Court, or at least up to a few years ago, all were more of the view that there should not be intellectual property rights. So I think we need to get behind some of these legislative changes. Maybe try to get them to be a little better. A couple of them are being, I think, almost outpaced by the changes that Director Squires is putting in place. But I think that we need to look to the legislature to fix this because I don't think the Supreme Court will. And I think that we have to recognize that if you're going to get tech and pharma to agree on anything, it's going to have to be narrow. It can't be a complete fix.
We'll come back to this subject when we expand the panel. Krista, do we we have a few minutes for a Q&A, or should we need to move on? Okay, perfect. All right. So with that, I think we want.
All right, so let's invite up back to the stage Donald Chisum of Chisum on Patents and Chisum Patent Academy, and also Professor Dennis Crouch. So Professor Dennis Crouch, we haven't heard from yet today, but he is a professor at University of Missouri and also the author of the Patently O blog, which is the most successful blog on patent law. And I'm really excited to hear all of their expertise today. So we touched on a number of really interesting topics today. Thank you so much. And by the way, speak close to the microphone because otherwise I won't be able to hear you. We've touched on a lot of interesting topics today, but I'm curious, is there anything that we haven't touched on yet at a high level that you feel like has been a huge change in the last 5 to 10 years? I'd be curious of what your thoughts, and then we can go deeper into each of those topics.
Great. Were you calling on me?
Sure. And anyone else? Yeah.
Okay, great. Yeah, so yeah, thanks so much for having me here. And when I saw that we were going to have this panel, I said, yes, Krista, I definitely want to be there because all of you have been so influential on my development as an attorney and then as a professor. So thank you, Don. Thank you, Janice. I can't assign Don's treatise to my class, but I do assign Janice's. So that's right. So one of the biggest changes that I've seen, I think, begins with what Don was talking about in terms of the creation of the Federal Circuit, which was, right, that was really created in a sense, right, and at least one of the stories is about centralizing and strengthening patent law, and did an amazing job of doing both of those elements. But then we've really had a series of steps following that in my sense has increased the political focus on the patent system. And today we're reaching kind of a high point. And so we had, right, with the Federal Circuit, along with what was happening with changes in technology, the Federal Circuit also linked that with patents, right? And so we have a lot of dollars. We got a lot of money at stake. And that continued. At some point, we had the America Invents Act. Before that, we had a slight change where the director of the PTO also became the Undersecretary of Commerce. And around the same time as the AIA, the presidents, and really beginning with President Obama, really linked the director of the Patent Office more closely with the White House. And so putting political directors, in addition to the director of the Patent Office, other political directors within the Patent Office to keep that line of communication open instead of it being a separate space. Then we had the AIA, and that made some changes, but in my view, not very dramatic in practice until we had Arthrex. And so Arthrex is a few years ago, and in that decision, the Supreme Court said, hey, the way we have to decide these inter partes review proceedings is not just through this judicial process of the PTAB, but instead, because of the Constitution, it's also a political process, and we need to have it connected politically directly to the president, right? And so what that meant was that after the PTAB decides a case, the presidentially nominated director of the Patent Office then also gets an up-down vote on whether that was proper. And then we've got this final step that has happened this year where Director Squires has said, you know what, I'm also going to take full authority at the institution stage of when IPRs are instituted. And these IPRs are important in that most of them are worth at least tens of millions of dollars, and many of them worth hundreds of millions of dollars at stake. And so, right, we've got really big business there. We also have parallel kind of another change that's happened. Earlier, right, in our first panel, we had some discussion that we have increased patent enforcement coming from foreign companies, particularly Asian-originated patents and now are being enforced in the US at a much higher level. We also had a change about 10 years ago, what I see is really like a tipping point change where now most US patents are sourced and owned by non-US entities. And so, right, and that was by design. The US designed this system as a way of allowing US inventors to reach out and patent globally. And that allows other folks to come to the US. But that is kind of a political flipping point. Because now if we're getting litigation and enforcement coming from folks outside of the US, it makes patents look much less politically sustainable. And so we have all of that, and kind of the crux of it is I am very concerned about the amount of lobbying that's happening outside of kind of the patent docket and outside of the docket of what's before the IPR. Because right now that we have political appointee with direct, right, required decision-making authority and power, right, we've got all sorts of avenues of going through the White House, through a senator, through other folks to influence those decisions. That is apart from the way that that our judicial system works, right? Instead, it is an administrative system.
I actually think that might be a nice segue to talk about IPRs first before we jump back around to some other changes, perhaps. You mentioned the increased political influence in IPRs, and we've had a huge change also pop up in the last couple weeks as well. So maybe you can tell us a little bit about that change, and then I'll ask others to jump in.
Yeah. I mean, so the IPR statute says that the director decides whether or not to institute an inter partes review. That's what the statute says. But up until about 3 weeks ago, that authority had been delegated to judges at the Patent Trial and Appeal Board, administrative patent judges. And so Director Squires has changed that, and at least in his announcement, has said that he's taking personal authority to decide each inter partes review petition, whether to grant that and move forward with a full trial or to deny that. And in addition, he's made clear that the purpose of that is to reduce the number of inter partes review proceedings, effectively making it difficult to challenge patents at the patent office, going back to the pre-AII statute. And just to put the nail on the head, so far, I think that he has decided 34 cases over the past 2 weeks. And in all of those, he has denied institution. And so that's where it was mentioned a 0% institution rate. That's where, obviously that is going to go up because it can't go down. But that's where we are at this point.
Yeah. And I'd be curious, Professor Chisum, how does that differ from the approach that we've seen for the last 10 years and perhaps at the beginning of the AIA? How does that, this current approach to discretionary denials and the high rate of discretionary denials, how might that compare to what we saw maybe 10 years ago?
How does this differ?
Yes.
Well, I think it was generally assumed that, the PTO was full in with instituting IPRs if they met the standard. In other words, if the statutory standard raising this question of patentability, I'm not quoting the word correctly. So maybe that was somewhat wrong from the very beginning. And, the legislative history talked a lot about, well, it wasn't clear that the PTO had the resources, had enough patent judges to handle this, but rather soon on, the Patent Office made it clear that since they were getting revenue to handle these, it was revenue neutral in terms of the federal government's budget. They were going to essentially grant them all unless they were barred. Now, maybe again that was a mistake, but if we're back to square zero, as Professor Kraut says, there's only one direction. Either we stay there forever go upwards. Adding to all this, if you don't follow in detail the case law, is the statute gives the director, the PTO, discretion unreviewable by the Federal Circuit or otherwise on the decision to institute. And that went all the way up to the Supreme Court too. But I get a little nervous about the politicalization of the process. Again, I think back to the oil states case, and was it Justice Gorsuch that and then later in the Arthrex case, he was, back to his theme that this is unconstitutional, taking away property rights by a political process. And that's why you have Article III courts that are independent of judiciary. So I'm more sympathetic to that than maybe a lot of other people think. Although I must tell you, because the reasoning in oil states, I should have written an article about this, but he said, again, it's like a continuation of examination. But remember, applicants, what happens to an applicant who is refused finally an application for a claim? They have an Article III district court remedy in Section 145. Everybody forgot about that. So the applicant actually did have such a right. And Congress made it very clear. IPRs are not reviewable in a de novo civil suit. So presumably that would be the fix. If that was the only constitutional problem, I don't know what people would think if all of a sudden Congress said Section 145 actions applies to IPRs. But you can think about it.
Judge O'Malley, I'm curious, you might have more insight into some of the lobbying interests that have driven some of the pushback against IPRs. Do you know where some of that lobbying interest is coming from, and what are some of their concerns that are driving that shift?
Well, yes, I work with the C4IP, and we are completely bipartisan because we don't think a strong patent system should be a political debate. But we're also realistic. There is a huge push from various sectors. Probably the strongest push is on one side is from big tech, because they think that things like the AIA will make their life easier because it's an easy way to get rid of patents. And they don't like being sued, and they also don't like having to worry about other people's intellectual property, because they think that their technology moves so fast they should be allowed to just do whatever they want to do, and let's fight it out in the marketplace. And then on the other side of that, you've got big pharma who desperately needs the patent protection because their technology moves so slowly and is so expensive, and there are so many different layers and levels that are required that they need some intellectual property in order to justify all of the time and expense that they put into their inventions so they can recoup something. So you've got two they have their own legitimate interests on each side, but they're both very strong and they both spend a lot of time lobbying. There have been some studies about who shows up at the White House the most. And under President Obama, it was clear that Apple was the #1 visitor to the White House for years and years and years. And you know what their topic of conversation was. It was only about patents and about why they wanted the AIA to be implemented the way that it was. So there are strong interests on both sides. I think there are also some reasonable people on both sides. And so I think there's a real interest in trying to come up with compromise. But compromise is never perfect. Compromise means no one's completely happy. And so that's what I worry about. I see these, I see C4RP, we get behind some of these bills and I just cringe because I know that I really was hoping that we'd do more or that the bills would do more. But I think that's what the problem is. Those are where the big lobbying efforts are coming from.
Thank you. And Judge Linn, I'd be curious to get your perspective. I'm trying to keep you out of the overly political questions too much. If we do see a dramatic drop in in IPR appeals due to increased discretionary denials. I think you mentioned that these IPR appeals were a huge portion of the Federal Circuit's docket. In 2023, they were 69% of the patent cases total, 69% of the Federal Circuit's docket. As you mentioned, a large portion of that being IPR appeals. So if we see increased discretionary denials, or perhaps if we see a continued 100% discretionary denial rate, how's that going to impact the Federal Circuit and its docket and how you do your work?
Well, maybe it will just result in an increase in the district court appeals, and that would be fine with me. I want to be a little bit indirect because a lot of these issues are percolating up before the court, and I have to be a little careful. But let me just comment generally that I think in the beginning, when the AIA was passed, I think it was well-intentioned. In those days, there was just a lot of discussion, big debates about patent litigation. It takes too long and it's too expensive. It's just getting out of hand. We need to do something to fix the system. So the idea was, well, let's come up with at least another opportunity to get rid of the bad patents that clearly should never have been issued in the first place. So we'll come up with this procedure where people can go back to the patent office, limited grounds to assert invalidity or unpatentability, and we'll put some constraints on the time that it has to be decided. And this will be a good thing, and it'll allow at least a little bit of a safety valve here for the clearly bad patents to get knocked out. But in practice, what has happened is just taken on a life of its own. And it's not just the bad patents that are getting knocked out. It's every patent, every case. And it's not only one IPR. It's, well, another IPR, and then another IPR. My concern is that, this is not healthy for the patent system. When I came onto the court, everybody knew my patent background, so they always said, well, you must be a patent, pro-patent guy. And I defended people who were asserting patents. I defended people who were being charged with patent infringement. So I saw it from both sides. I'm not pro-patent or anti-patent. I am pro-patent system because I think the patent system is critically important to innovation and to the health of our economy in general. And I see this out-of-hand IPR proliferation as weakening the patent system. And people are now looking askance at the patents because they see this out-of-control system and they don't think it's a good idea. So that disturbs me.
Can I add one more thing? I want to add something to my prior response, and that is that there is a third group that gets ignored all the time, and those are the small, independent, individual inventors. I think they feel that they've taken the brunt of this. That I actually truly saw a brief once out of the PTO that said our job is to protect the American public from bad patents and to decide which are the bad patents that the people need to be protected from. It was such an absurd statement. I walked down the hall to one of my colleagues. I said, "Did you see this?" And his response was, "Man, from a political standpoint, that's one of the dumbest things you could ever write in a brief." But what's happening is, I'm afraid that a lot of the definition of bad patents is falling really hard on those individual inventors who have really good ideas but can't afford to fight the fight, don't have the sophistication that these big companies have and the lobbying arms that these big companies have. So I think that that's a third group that we need to keep in mind.
Absolutely, and that ties a little bit into with the MedTech panel that we were talking about how a lot of folks will try to go after medical diagnostics claims, but the sophisticated people with counsel will do the same thing with an apparatus claim, and then it's not called a bad patent anymore. Right? Anyway, any final thoughts on IPRs before we move on to some 101 questions? No? All right, Stephen, I'll turn it over to you.
All right, at the risk of beating a dead horse here. We've talked a bit about eligibility, but I want to just dig into the para bill that's pending and being advanced by Senator Tillis. Part of it, I think, is swan song in the Senate, pushing that along, or trying to push it along, I should say. Maybe I'll start with you, Professor Crouch. What would para do, and what are the chances you think that the bill gets through Congress?
Yeah, great question. So we have this bill para that does not completely eliminate the eligibility doctrine, but narrows it at kind of an extreme level, so that essentially, I think that in reading it, I think that we would go beyond even where we were, in like the year 2001. Law professors were writing articles such as "Everything is Patentable," where there was an idea where eligibility was not an issue. The first year I taught patent law, was 2006. I basically skipped eligibility as a doctrine. I basically skipped it because it was not relevant, and so the para bill would effectively take us there, and I think maybe even a step beyond that. And so I think this goes to Judge O'Malley's point. At this stage, it's not politically viable because it's so strongly favoring kind of one set of interests that there's essentially no way that what's there now is going to be a compromise. Now, there were some changes, right? This has been proposed over the past few years in some form or another, and there have been some changes where there was essentially some lip service towards toning it down. But if something, I think there is a chance to get something passed in the next year and a half during this Congress. But it would need to have some major changes so that effectively the idea of preemption, which is kind of the fundamental justification for this whole system, so that the idea that there are certain things that should not be cabined in by property rights, but instead are available to all people, that really is in there. And the current bill also just suffers from a problem of, the language we have now was written 1793, effectively, and has barely been amended for the past 200 years. And this new bill turns that beautiful sentence into multiple pages. And I would just I'm okay adding one more sentence, but I would love it to keep it short and simple to the point.
Professor Chisum, we know what you would like to see. You talked about that before in terms of reform of 101. Does, in your mind, can para be a solution? Is there some common ground? We've historically had to solve some problems. Our Congresses had to solve problems that seemed intractable, that there just couldn't possibly reach a solution. Is there some possibility that you can thread the needle, satisfy big pharma, big tech, and the as Judge O'Malley referred to, the small inventors?
So I think the answer is no, but is there some possibility that, in terms of legislation, is that what you're talking about? I am so skeptical, though, about legislation today. I almost developed a habit, I shouldn't confess this, because there have been proposals to amend the patent laws constantly over the last 50 years, that time capsule. And I stopped even reading the various bills that were proposed because they almost inevitably were not enacted. Now, I proved wrong with the 2011 America Invents Act, but it's just, and we had one specific bad experience. I forget the exact title, but the biotech industry became very panicked about how Section 103 on obviousness was being interpreted, and they read a Federal Circuit case as making certain kinds of process claims. So they convinced Congress a very specifically worded amendment to Section 103, which turned out to be worthless and confusing. And the Federal Circuit clarified what their position was, making it ridiculous. So I have a deep ingrained skepticism about, and I totally agree also about amending with specific language to overcome a court decisions on a very fundamental point about the patent system. And I'm with Professor Crouch, though. The beauty of the patent system is it's old, it's settled. After all, it is about property rights. And we shouldn't give up at this point and say, no, we just have to keep, because you amend it once, then future technologies are going to come in, and whatever you put in is probably going to end up being awkward. So I'm sorry. Back to basics. I wouldn't start all over again with the language that we have in Section 101. It is our history. You can look at the European Patent Convention, which is reasonably workable, except they have a bunch of specific exceptions which they managed to get. But they have a very general statement that essentially inventions are patentable, and except games are not, and that sort of thing. So,
Judge O'Malley, Judge Linn, any final thoughts on the prospects for 101 reform?
You know, I do think it's entertaining to watch some of these senators running around. There's one proposal that says we should just wipe out all the law as it relates to 101 right now and go back to the everything under the sun is patent eligible. There's a certain appeal to that. But I do think that PARA actually has a lot of compromises built into it, and it's attempting to mimic the European system. So it has a list of categories that are not patent eligible, and then it has certain exceptions, and it does refer to a lot of the issues that Professor Crouch is mentioning as well. So I think that it is a compromise bill, and I know that there is some buy-in from both sides. The one category that doesn't like it are the individual inventors, because they are they're of the view that the perfect should be the enemy of the good, which is too bad. But I do think PARA is on the right track. It needs some more tweaking, and they're having more hearings. So I just keep being surprised that it doesn't go away and that it keeps getting introduced. So I think we might see something in the next year and a half on patent eligibility.
I just add one more thing. The director has been very vocal about his views on 101 and seemingly trying to move the law through how the PTO examines patents. I trust, again, we kind of going back to what Professor Kraut said, is the system has, in a way, become more politicized, right? The connection between the director, Undersecretary of State, and the White House. I presume that the White House is on board with 101 reform. Is there something the White House can do, the president can do to try to move the needle with his own party and get enough support from the other side of the aisle?
Yeah, I'll jump in there, and I think absolutely yes. And if we just look back on, I was also surprised that the AIA passed. I was right. I also think just odds are it's not going to pass. But one thing that led that was USPTO Director Kapos worked very hard to focus in with folks, lobbying in Congress, and working towards compromise. And right now we've got Director Squires, and we also have Secretary of Commerce Howard Lutnick. And if Secretary Lutnick pushes this, that's the way it's going to get. That's the way it's going to happen. Because he also has tremendous political capital, is also the inventor on hundreds of patents. But in my review of his patents, effectively all of them are ineligible as abstract ideas. Because he ran a financial services organization, and essentially all of his fintech patents are abstract ideas under Alice, Mayo, and Bilski. And so he has a compelling story. Of course, he's very busy. But if he, that's the way, if he picks this up and champions it, it's going to pass.
Of course, he does have the view that he is going to balance the budget personally, and half of that is going to come from these new fees that he wants to put onto patent owners. So he needs to have some patents around to get the fees.
So maybe we can turn a bit to another topic, which is trade secrets. So Congress enacted the Federal Defend Trade Secrets Act in 2016, about 10 years ago, providing a federal claim, whereas previously trade secrets were handled under state law. And this happened at a time that we were also seeing that shift to more patents being ineligible and greater difficulty in finding patents eligible. So I'm curious, what was the Defend Trade Secrets Act trying to solve for? Has it succeeded? And how do we balance that against some of these changes to patent law? I might start perhaps with Professor Chisum or Professor Crouch, and then jump over to Linn and Mallie.
Okay, yeah, so trade secret law, right, we're coming up on the 10 years, was DTSA of 2016, so next year will be the 10-year anniversary of our, right, and really the key point of that was to transform trade secret law from state by state law into a national law. And to some, that was added to what was already in existence that was known as the Economic Espionage Act that allowed for some trade secret cases when U.S. technology was stolen, and also for the purposes of being taken abroad. But this expanded it to also domestic trade secret enforcement and enhanced the approach of having civil cases. It has been, now there have been hundreds of DTSA cases that have gone all the way to trial. There's been thousands of them that have been filed. In most cases, when people file a DTSA case, they also file it in parallel, also alleging state law trade secret violations. But there is this beauty then that you get into federal court, with elements that come with it that a lot of litigators like. The one thing that I looked at last year on DTSA cases that I was curious about. Look to see, is it still true that the vast majority of trade secret allegations are former employees who have left and taken something with them? And my answer I found from the complaints was yes. That still constitutes the vast majority of trade secret cases where we have an employee who's left, maybe they go to a competitor elsewhere, and then we have a subsequent trade secret, and we also have a breach of contract lawsuit, and that continues to be the approach. And so, what that means, it is an IP issue, but it is largely now also kind of an HR issue, and so it's a little bit shifted. Now, although that's true, there are this small number of cases where we do have what might be the way that we classically think of trade secret violation, where we have someone, going into the factory, taking it out, and giving it over to this complete competitor, the technology itself. And so that is still happening. And there's a couple of beautiful aspects of the DTSA and I think the key one of how it's been interpreted by the Federal Circuit is that is to essentially allow for foreign damages, so if the damages come, even if some of the activities are happening in China, we can still collect all of those with a U.S. trade secret case, and we have had some very big judgments.
Well, I haven't followed this particular area of the law very closely, but one interesting feature about trade secret law for former employees is the California situation. Because the state of California has a statutory provision essentially invalidating employee agreements not to work for a competitor. So this is sort of like a Silicon Valley problem. And so instead, an employer, you've got to rely on trade secret protection. You cannot use a contractual restraint because that's unenforceable. And okay, you said that's just one state, but remember, this is California. I used to teach law at Santa Clara University, and you say, why? Well, that's in Silicon Valley. And by the way, Santa Clara County is the second or third largest state in terms of number of patent named inventors. You say, well, it's not a state, it's only a county in California. But I mean, that's so huge. But the point is, you get situations where you have to rely on trade secret protection. You cannot use the contractual route, which is, some people argue that caused companies to move from Silicon Valley to other places, like up to Oregon or somewhere else that does not have that statute.
And I might ask, Judge Linn, have you noticed any increase in trade secret issues, or do they tend not to really pop up at the federal circuit quite as much?
Yeah, those issues really don't come before us, unless they're tied into a patent case.
Right.
So we just don't see those issues.
Makes sense.
I have a question.
Yeah.
So you mentioned the big patent verdicts, the big trade secret verdicts, and this may be anecdotal, but it seems to me like every time I hear about a big verdict, it gets reversed. So are there any big damages awards that actually have stood?
I think I have to say that I don't know the answer to that. In terms of how much gets
that's your next
how much
survey.
gets paid. I know that. So there have been some that there have been a good number that have withstood appellate review, but there is always that next question of, okay, do you actually collect the money? And I think that's what I don't know. And so with trade secret, in patent law this past year, we had a key en banc decision on damages, and the Federal Circuit has a number of cases from the past few years that are trying to kind of tighten in the analytical approach of how we treat expert witnesses in damages, and I remember one district court judge that I spoke with one time who told me off the record, he's like, I feel like I can't believe anything that comes out of a damages expert mouth. Whatever side they're on, can't trust any of it. And so the Federal Circuit has worked hard on that the past year, and none of that has happened in trade secrecy jurisprudence. And we also don't have as Judge Linn suggested, trade secret appeals are not centralized to any particular court. And so instead they go to whatever circuit court of appeals, or if they're filed in the state law, they go, through the state docket. And so that does open things up to kind of a choice of forum issue where folks can jump around. As one circuit is doing something to push things down, there's others that may be letting up.
I will add, as somebody who's worked with a lot of damages teams, I was on a damages team in the Intel VLSI case, and I will say that adage about statistics is also true of damages experts. There's lies, darn lies, and statistics. The same is true of damages experts, because it's very easy, given the flexibility of the standards, to if you have a good expert to pump that up or push the other sides down. All right, so I want to leave enough time for questions and for a few other topics, so I'll turn it over to Stephen for one of our final topics.
So I'm going to talk about litigation funding. There was a panel earlier that covered this subject, but there's some pending reforms related to litigation funding. It was mentioned earlier that this summer there was an effort to attach to the one big beautiful bill some tax on litigation funders that didn't actually make it into the legislation. But we know that there's some hostility, certainly in the business community, toward litigation funding. The U.S. Chamber of Commerce, the state chambers of commerce all seem to be pretty uniform in opposing the litigation funding as a tool. The legislation didn't get through, but where do we stand on this? You know, in the courts too. Actually, I guess I should mention this: that in the courts there are disclosure rules in Delaware and New Jersey are notable for requiring a disclosure of those who are relying on litigation funding to reveal their backers, their financial backers. Very controversial, and has actually led to a shift of cases, litigation-funded cases, away from Delaware. In New Jersey, I suspect the same. So maybe just start with Judge Linn. Federal Circuit is it's taken up some issues related to litigation funding. Does it have any kind of disclosure rules from the Federal Circuit perspective? What can you say about what's been decided so far?
Oh, this is an area where I do have to be careful because this issue is likely to bubble up before us, so I just don't want to comment.
Well, that was short and sweet. Thank you. Saved us some time. Judge O'Malley, you have a little bit more freedom now. Do you want to talk about this?
Well, in reality, it's basically come before the Federal Circuit so far only in a mandamus context. And that's such a tough context for any litigant to survive. So I think the Federal Circuit has probably rightly denied mandamus, though sometimes I wonder if they couldn't have been a little more bold, because I don't think that the district court should be getting involved in who's paying for somebody's litigation unless there's some substantive issue that is affected by that. I mean, look, we've had insurance companies pay for counsel for years and years and years. And that doesn't mean that the parties are illegitimate or shouldn't be allowed to be in court because they're having their fees paid for. So I don't think it's the place of the courts to be second guessing the funding. I missed the panel this morning, so I apologize. Maybe there was a lot of discussion as to why courts should do that. But I understand that there might be some legitimate concerns that state legislatures would want to look into. But I just think we have to be very careful before we go down that road, because there's lots of other instances in which things have had to be funded by third parties, or the cases couldn't have been brought. And I can tell you that the small inventors think that they can't survive without litigation funding. So when you start to say about equities, if you're the small inventor and you think you have a great idea and someone else does too, and they've got money to help you protect your patent or your intellectual property right, why is that wrong necessarily? So I just don't understand why there's such a big push on this thing.
Yeah, how is it different than having a contingent fee lawyer representing? What's the difference? A law firm takes the stake in the case versus a litigation funder providing the source of capital.
Yeah, I'll jump in there. And it really is the same in that the Chamber of Commerce also has repeatedly asked for limitations of contingency fee attorneys because that does provide kind of access to justice of someone who doesn't have enough money. And for many years, there have been patent cases. There were a number of plaintiffs' patent attorneys who focused in on being contingency fee lawyers, but there was really just a limited number because it takes, right, these cases drag on for years and are extremely expensive to litigate. And most law firms are not in the business of delaying getting paid for multiple years. And anyone who started doing that, people had to leave their law firms and just open essentially a solo practice to be able to take those kind of cases. And what litigation funding does is transform that so that the law firms still are taking on some risk, but they are also getting, typically they're getting maybe like 40 or 50% of their hourly rate getting paid to them from the litigation funder. And then if they win, they get the rest of it. But essentially, you're able to satisfy your partners by bringing in some money and shift the risk onto somebody who is basically an investor. That is, right, essentially being an investor is somebody seeking risk so that you get this potential big reward. And so it divides up the relationship being a lawyer. And so I see it as the same thing as contingency fee attorneys and is a powerful tool for getting access to justice. Now that said, so one thing that's prompting all of this, right? So one thing's prompting all of this is just people don't want to get sued. And so they want to limit plaintiffs. But another thing that's prompting this is a couple of years ago, we had this IP Edge case that was in Delaware. And in that particular case, we had some real, what looks like unethical behavior, violation of individual lawyers' rules of professional conduct, in that doing things like letting the funders make the decisions without even informing the client, who was really kind of just a straw client put in there to have a name of a client. And so that mix was such a problem. That's what got Judge Connolly so up in arms, because he really felt like people were doing the wrong thing. And since that's what that judge saw, I think he had the assumption that that is how the industry was generally operating.
Is there also a sense that the source of capital is foreign? The patents being asserted are foreign patent rights, or is that an element of this?
Yeah. So I have, so I raised that question earlier, and and part of that, it plays well in politics to announce that it's an attack on America, and so there is some of people playing that up. But it is also true that there have been, I've seen reports, and it is folks with a vested interest, but it appears to be credible that there is a good amount of foreign investment into these vehicles, right? Foreign investment into the funds that are then funding litigation, and the basic, it starts to be a concern, at least in my mind. We have one thing where in the U.S. it's fun to complain about corporations not having a heart and not caring, but then, if it is an American corporation run by folks here, I have a sense that the people running that, because they are here and living here and are part of our country, have some kind of civic thought, some civic obligation usually, and are working towards the betterment of our society and our country. And so we have that's not true, right? And America has a number of enemies abroad, and so there is a concern there.
I think that leads us a little bit to our final question, because I want to leave time for others. We talked about competitiveness, in the U.S. competitiveness, and how all of this ties into that. And earlier we heard Judge Linn mention this desire for a patent system that works well. So how should the patent system be structured to work best, whatever that means for you? And what are the key qualities of that system? Maybe we'll just go down the line this way for everyone's sort of final comment on that.
Wait, starting with me?
Yeah, go ahead.
Oh gosh, I don't know that I have an answer.
Okay.
Well, so I'm going to steal from Professor Chisum next to me, in that I loved his discussion of Occam's razor, and I have a real concern right now about one element of what's happening at the Patent Office, and that Director Squires I think rightfully believes we're in the wrong place with eligibility doctrine. That we are in the wrong place, and he's now in a position of power to shift that, in that he can tell the examiners what to do and what not to do. And I think that's happening. But it raises a real concern in my mind that we have different standards. We have one standard at the patent office. Then when those patents get issued, the courts don't have that power. The courts are going to follow what the Supreme Court and the Federal Circuit have said. And so I am so concerned that we're going to have a bolus, a large throughput of ineligible patents that are going to be essentially this new round of, oh my gosh, we've got a whole set of bad patents out there now. We've got to do something else to get rid of them. That this is going to drive a whole nother wave, a new pendulum swing that is anti-patent. And so I'll just do that one issue.
Professor Chisum.
Well, I concur in Professor Crouch's opinion, but what you just said, I flinched because we've been there once before. Exactly. We were there exactly. There was this Federal Circuit decision by, bless his heart, Judge Rich, that talked about there was no exclusion of business methods. And taken in context, that was fine. But hordes of people jumped in and started filing patent applications for every kind of business method, particularly if it was carried out over the internet. I remember I was teaching in Santa Clara then, and there was a gold rush to end all gold rushes. In fact, naively, professor that I am, and I said, we ought to this is an important new decision. There's a lot of interest in it. So we scheduled a little, a seminar like this, sort of, in the largest classroom in Santa Clara, and it was announced. And there was huge numbers of people. Nobody could get in. They were lined up, attorneys and others. So there was a rush of these applications. The PTO apparently issued a whole bunch of those, which ended up inducing Congress to do what? They passed this statute, for what it's called, controlled business method or whatever. They to have a special kind of post-grant review to take care of this huge surge of patents, many of which were thought to have not been adequately examined under this, not so much 101, but under, Section 103, Section 102, what was the prior art. So I fear for radical, quick changes in PTO practice, saying, oh boy, here we go again. I don't know. For us authors and teachers, this is not necessarily bad. This makes for interesting discussion at seminars, but is it good for the health of the patent system? And the answer is no. So,
Judge Linn.
Yeah, we talked about 101. That certainly needs to be addressed. We talked about sort of IPRs being runaway and out of control. That needs to be addressed. One thing we haven't talked about is that the patent system would benefit from better quality patents. And I think the patent office, case after case that comes before me, what are we talking about? Claim construction issues. What does this phrase mean? Well, that should have been sorted out in the patent office in the first place. And I can still remember, it was a long time ago, but I was an examiner. And in those days, we didn't pay much attention to 112. If it was a lack of antecedent basis, that was an easy rejection. Fine, that was an easy fix. But beyond that, we didn't pay much attention. But that was because the technology was very simple in those days. The technology now is much more complex. And the wording used in the claims has become much more sophisticated. Practitioners who write applications for these complex inventions, I think they know darn well what they're doing in writing language that can be read this way, that way, or the other way, because they want to be able to argue that after the patent issues, depending on which way the technology goes.
But the patent office is entitled to call them on it and make sure that the claims are crystal clear before they're issued. And that would help tremendously.
I do have one point that I want to say, but this is a funny segue because when I was an adjunct professor at Case Law School, not to mention the enemy down the street, but I taught patent litigation and I kept saying, you need to get more clarity in your claims. And somebody raised their hand and said, I'm also taking a patent prosecution class. And the prosecution professor said, make it as confusing and vague as possible. So now this was a long time ago, I'm dating myself. But anyway, if I could do one thing, I would get rid of that horrible eBay decision. It was wrong as a matter of law anyway. The court, there was never such thing as a 4-part test after the fact. If you've got a valid patent, it's infringed. I mean, you don't really worry about the balance of hardships in that circumstances. And so the court didn't even understand the basic law that it was applying. But what it has done is every district court is afraid to grant an injunction. Even when you've got a valid patent that's clearly infringed. Every other country in the world allows injunctions. So what we have is we have patents that are not really enforceable. So it becomes a question of if you are infringing a patent, it's just more efficient to go ahead and keep infringing. Because at the end of the day, if all you're going to do is pay some money, there's likely to be a discount on what it is that you would have to pay. The Restore Act is actually brilliant because it's very clean, very simple, just restores the presumption that at the end, and this is not for preliminary injunctions, this is for permanent injunction, restores the presumption but recognizes that the court has the ability to deny injunction for a whole host of reasons, like the traditional reasons, like public policy, et cetera. And I just think that I don't understand why that one can't pass. I think it's just caught up with all the other things that Congress can't do. But it's a simple act, it's a simple bill, it gets rid of the big mistake that the Supreme Court made. And if you remember, the Supreme Court in eBay actually mentioned patent trolls. I mean, why does that matter to what the law was that they were applying? Well, that was their motivation. They completely bought into that dialogue, and as a result, they messed up the law. And now we are at competitive disadvantage with the rest of the world.
Do you folks have time to stay over for 2 more questions, perhaps from the audience? Okay. All right. So we'll take 2 questions from the audience, and then I won't keep anybody from food after that. So 2 questions, maybe, max. Anyone? All right, go ahead.
There is something very appealing about the idea of just repealing all the 101 law and just getting rid of it. I mean, when everybody that's ever read any 101 case realizes they could have been decided as a 102, a 103, or even a 112 case, and the fact that they using 101 seems frustrating. So there is something very appealing to that. I almost wonder why we couldn't go that route and just get rid of it. I mean, I talked to some tech companies and they recognize that too, but they really like the gatekeeping of the 101 motions that they can do early on in the litigation. And it just saves them money from having to battle it out as a 103 case later on or a 112 case or something else like that.
Judge Lurie wrote several opinions early on saying, look, this goes away under 112. This goes away under 103. Why are we even doing this, or why should we do this as a threshold? And then he basically decided he was hitting his head against the wall, and he wasn't going to carry the day on that point. And you're right, the tech companies love the threshold because they wrap 103 and 112 into it, even though that theoretically shouldn't be. But that's what happens.
I'll just mention, since in our current era, since the 70s, the Supreme Court has talked about eligibility being wrapped up in the statute. But kind of one caveat to all that is that older cases highlight it more as stemming from the constitutional provision. And so I expect that, right, if we eliminated it all, the Supreme Court would still say, we still have some power here. We still have power to do something, but probably a lot less than what they're doing now.
Question from Carl.
One comment, Judge O'Malley, we miss you in Chagrin Falls. When we trick or treat with my daughter and their friends, we still call it Judge O'Malley's house, just so you know. My question is this: I wonder if anyone has any comments on what's going on in the Eastern District and Western District of Texas with forum shopping, and whether that's something that needs to be fixed.
Well, I don't have any specific information, but I think if one did a very in-depth study of Federal Circuit decisions by district, they would probably conclude that there was a higher, more probing standard of review of decisions coming from those Texas districts. That's just off the record, but I think there is, anyway, a suspicion there. But
the Federal Judicial Center did do a study in which they were trying to determine whether or not there were fewer reversals from courts that have a lot more cases, and the answer was no. That there were actually fewer reversals from one-off decisions in other districts, but I suspect that they never really looked behind why that might be, and I suspect it is that maybe you're hearing too many things coming out of too many particular districts, and maybe the Federal Circuit is skeptical, and so that's why there's more reversals. I don't know.
Yeah, I just read this week a couple of Federal Circuit cases that I'm like, why did the district court do that? Right? They were getting reversed, and then I looked at the name of the district court judge, and it was someone who has not done very many patent cases. Because, right, this is a very complicated area, and one of the beauties of having somebody who's, right, a judge who's handled dozens of, right, or maybe hundreds of patent cases, is that they do know the law really, really well. To some, right, and some folks don't like that, especially when they know the law really well and are still letting this go to trial. But I feel like it got to be concerning where we had a couple of different times where over the past 20 years where a single judge has had about 25% of all the cases in the country. And that level of concentration just seems to be problematic. And it just feels a little wrong for the whole nation where we have, hundreds of district court judges to have that concentration, potentially a problem. But at the same time, those folks, I believe, are doing a very good job, right? They're not, right? They're really judging. And the cases are really going through, and they're not saying you always win, you always lose, right? It's not coming out like that.
All right. Well, I think that would be a great place to close this off, and we can go enjoy some food. So thank you so much to our panelists.